you're so cold. Tell me what's the score? You say you hate me over grape, is that all? Come on, girl, let's face it, we had a ball. Why can't you see that you are mean to me? I'm losing sleep, baby, can't you see I'm tired of playing games? I just wanted something on the side, my wife, oh my girl, I won't let you go. We met on Facebook or at the gas station. I took you to Cheddar's and a movie, and you didn't mind I catfished you at first, but my nephew was a snitch, that little bee. Why can't you see that you are mean to me? I'm losing sleep, baby, can't you see I'm tired of playing games? I just wanted something on the side, my wife, oh my girl, I won't let you go. We met on Facebook or at the gas station. I took you to Cheddar's and a movie, and you didn't mind I catfished you at first, but my nephew was a snitch, that little bee. Whoa, it's that little bee. Whoa.
Oh my God.
Jimmy, why was that, Jimmy?
I was not expecting you to do that.
I don't know what you mean. I think it's Marissa. She has controls too, so it's probably her who did it.
Mm-hmm. Blame
Don't
Marissa.
let me touch AI.
Why not? It's funny.
Well. Hey, Jim Cox, how are you doing? Yeah, please hit the like and get the people notified that we're going live. Happy motions in the ocean today. Hey, I'm Young. And Miami Spice, Helen from Holland. Left Day. Fupa. Erin Oliver. No, I didn't change any time. I have set it for this time, all day. West Guy. And Amber, good morning to you as well. Yeah, we are almost at trial, finally. Probably nothing happens tomorrow. So,
Oh my gosh.
if nothing happens tomorrow, Jamie will be here.
In this crazy world, girl.
I will be.
Hey, Caroline. And Danny Tay. We love you too, Danny. And Secret Squirrel, good morning. Chelsea B. Hola, how are you? Mr. Valhalla, you have the link. Matti Abbianati. Good morning, T-Rex. Ralphie.
Hi, Ralphie.
I don't know what cheddars are, but I might have to catfish people and take them to the cheddars. No.
Isn't Cheddar's like just a fast food restaurant?
I don't know. I don't live
I
in
don't know either.
America. And just, I'm
Sounds like
so
it.
far from artist. I'm just, my brain is weird. Don't let me get near AI anytime soon. I can make new songs tomorrow.
Were you having a ball making that? I know you were.
The ballad of Roger will be the next project.
Oh my gosh.
Hey, Chrissy. You could also call it Swasia 100%. No, as I saw it, they were just told there would be police officer making sure, and that the Tom group should tell the police officers if any trolls arrived. No, I had a backbone. It took me only 45 minutes. Hey, Betsy. And Panella. Månedsnibbles. Hey, Tracy. How are you this fine morning? It isn't crap. I think you did well. Hey, Beth. Hey, Norma from Iowa. I think today will only be motions. I don't
Yeah.
think it'll be a long day because she'll do what she always does. Said, "Yeah, I read it. You delivered extensive paperwork. I'll make a ruling in writing."
Oh yeah, I'll take it under advisement.
Yeah, the Bears are
Sir.
2 hours away from drafting Caleb Williams, so that's exciting. KKB. Hej, Vejnesår. Hvordan går det? It's a sit-down restaurant like Applebee's or Ruby Tuesdays. It's not good.
Oh.
No, you're catfishing the ladies. You don't have to. Yeah. Yeah, that's what I saw too. They were saying, especially that they were told that if the JLR shows up, they should notify police. Rolling Stone. And we have all from court.
Nice.
Oh, I haven't used them in a long time. Now I have to remember to do this so they don't get mad. I don't know who Giants are going to pick. They're probably going to pick a new quarterback because DJ isn't a good quarterback.
We'll see.
Yeah, please hit that like button so it helps me to get recommended for other people who want to see Karen Reed cases about the Karen Reeds. The draft starts at noon Eastern. I don't know. Hello, Oksana. How are you? Oh, that's a beautiful picture with all those tulips in the background. I was making my coffee, so I didn't even see it when she arrived. I just heard some get excited.
We've just been leaving while the court still.
And hey,
Not
sis.
making it already.
And for those of you who weren't here yesterday, I moved over to a Baker-only Discord. There's a new link in the member tab. It was just because I've been on 2 shared Discords, and some people have asked about something where it's only me, so we did that. So if you want to join that, you can go into the members chat. I think we have sent out invites to a lot of people. If you haven't got it, it's not because we don't like you. It's Jamie was ordered to do that, and she said, "Nah,
Too much work.
It's a Wednesday. That's my mean day."
That's my mean day.
Er du 17 år gammel, Vejnesår? Eller bare lidt sent ude? Are you saying that for me? The Discord? No. It's just a general statement. So people knows that they can come back and come into the Discord. We were having fun in the chitty chat room yesterday.
Mm-hmm.
It's really nice when we don't go to 11 my time, so we can sit and talk a bit and lashes is often one of the themes we go through.
Whatever. I do have a lash appointment today, so. I'm excited.
We got one of those
because they're
camera guys who
looking
wants to.
really, really crazy today.
You're telling her you want those that goes out all the way up here?
I want I tell her I want the stripper lashes. That means lots of volume.
The umbrellas,
Mm-hmm.
as they are.
I tell her all the things you say to me, and she laughs so hard.
Ask Jamie about a tiny blow dryer for her lashes.
Yeah, I got a little blow dryer for my lashes because you gotta wash them, and then you can blow dry them to like fluff them out. There's I have a fan and a little blow dryer thing and all kinds of stuff.
I have 2 beautiful young women as my daughters. I know more about feminine makeup and all the hacks you use to catfish us men after streaming with you for a year.
It's only eyelashes. Like I barely wear any makeup other than eyelashes. So
Hmm. Yeah, I've seen those tutorials on YouTube where you start out with someone who looks older than me, and I'm 27,
no.
so that's old. And 5 minutes later, she looks kind of like a crossover of Nina Agdal and Emily Ratajkowski.
Yeah, no, I don't. I can't I don't know how people do that. I mean, if you do, it's fine. I mean, if you make it look good, but like I can't stand the feeling of all that stuff on your face.
It's more than a feeling. Hey, Sue.
I like blush and eyelashes. It's pretty much my go-to.
Well, you're a natural beauty, so you don't need it.
No. Well, thanks.
Hey, Pete's Pony. Just motions. So I'll bet she'll do what she's done at the last 3 motion hearings. Just say if there's anything big, they'll get to argue for 10 minutes, and then she will say, "Yeah, you have delivered an extensive written material, so I will consider it." So sadly, I don't think I don't think we'll get much new. Well, last time we got the third-party culprit into it. We
Mhm.
know the DNA has been admitted last Monday. Anything else spicy? Well, the change of courtrooms, but that doesn't really matter. I saw my favorite idiot after Grant blocked me, Caffey Daffy, said, "Well, that would be bad for Karen Reed because all her supporters can't be in the room." It's not a football match. It's not like they can sit down there with flags and beer and yell, "Go, Karen, go, Karen, go."
Right? Oh my god. Yeah, that's the dumbest thing I ever heard because it doesn't matter. Yeah, it's not like they're gonna cheer for her.
While we're watching the clock, Lefty, we're trying to teach you how it is. And as you can see, the long arm is a little more than 12, and the short arm is at 10. That means it's a little more than 10 o'clock. I thought today is actually rulings on the motions filed at the last pretrial hearing before jury selection began.
I hope
Yeah,
so.
but most of them she said she would do in writing. Hey, Zach, how are you doing?
Hi, Zach. I am
Hey,
doing
K.
something
Marshall.
fun today. Thank you very much.
He's going to turn into Coxwork. Clockswork is the word, not Coxwork. Did you see that little B word? I opened his channel because I'm a supporter of his, as I am with a lot of people with special needs. And then I heard my beautiful voice.
Okay,
He just
talk about
he put on my audio while he slept. That's a genius move, and he didn't even put my link up and said. When I heard your voice, I thought that's the most manly Lefty ever heard. Sounded like because you sound feminine, but not that feminine like him.
I did too. I pulled it up. I'm like, he's still alive? Jeez. And then all I could hear was like, wait, that's Baker and me.
Yeah, it's Coxworth. Clocksworth. No, I don't. I hadn't watched it in a long time. I like that movie. Not the live version, but the drawn version, the cartoon. That was a good one. Bears are 11 hours away from screwing up another quarterback. Well, the Giants will be right behind them. Sorry. You woke up to a grape trial in video games. Best of both worlds.
Yeah.
And a milkshake tummy. Oh, we had banana milkshakes at the McDonald's but they only had them for a short period. I love everything with the artificial banana flavor.
Really? Of course you
Mhm.
do. You hate everything that's delicious, but you like artificial banana?
Yeah,
You're
that's
you're something else.
no, but I really like it. I don't know why, but I always in Denmark we have what's called foam bananas, where you have like a kind of a marshmallow filling with a banana flavor, and then it's chocolate covered. They are good. They're so good. I can only buy them one time a year. I'm in Germany, or I would eat them all the time. But then you can get the big box of them. Mm-mm-mm. And then
You
you
like
feel
banana flavored
really.
candy too?
Did a what?
I said, do you like banana flavored candy too?
Yeah, I just said we had like marshmallow with banana flavor covered in
Oh, I
chocolate.
meant like, well, that's like different, but like candy. You
Dude,
must consider candy different than what we consider candy. I don't know.
everything sweet is candy, and then there's different kinds of candy. You have hard candy if that's what you're thinking about.
Yeah, like hard candies and stuff.
No, I don't like hard candy.
Okay, well then. Because they got like oh my God, Laffy Taff. I love Laffy Taffies. They have the
Because I
banana
like the fake
Laffy
banana
Taffies.
flavor.
And that's like the one that no one ever wants.
Why would people be mad that you said to use grinder? Marshmallows are candy for sure. Yeah. I love the chocolate covered banana marshmallows. Yeah, they're great. No, but we have you have wine gums, you have licorice, you have hard candy, you have do you call them I know I probably shouldn't say that. The the thing that Hollywood filled with cocaine so they can go and it's like hard candy on a stick.
Like
I think there's a famous American brand name called Chops or something, Chopper Chops or something,
Chopper Chops.
Choppy Chops, Choppy. I don't know. It's a hard candy, a round hard candy bowl on a stick, and a lot of Hollywood people were seen with it, and then they found out it's because they put cocaine in it.
Oh my God, I love you, Val. You're so ridiculous.
Yeah, you should try chocolate, not that weird stuff you eat. Lollipops, that's the name. Yeah, but this is the word I didn't want to say because someone would clip it.
Lollipop?
Yeah, lollipop. They put cocaine in them back in the days in Hollywood.
But you didn't want to say lollipop?
No, I didn't want to say because I couldn't remember the name Lollipop, and they even is a famous song. My girl, my boy Lollipop, my girl. You're my pet. Nah, thank you so much, T-Rex, for the super chat. Of course, Baker loves bananas.
Yeah.
No, I love artificial banana flavor. Let's not take this out of context.
Don't we
My mom
always?
was allergic to bananas. But when I'm being a real good boy and remember not to eat too much and having a shake instead when I'm at the gym, a protein shake
Good
with a
job.
banana in it is real good.
Look at you.
Hey, I said when I remember it. Hey, Chrissy.
When
Yeah, I was a period. I was really good at instead of just eating when I got home. I took a shake, just a protein shake with a banana in it, and some kale because that should be healthy. But kale tastes like dirt when you blend it. Hey,
that's why you
Steven.
mask it with a bunch of other things.
Hey, Schomburg. Yeah, and then you put in a lot of sugar because it takes away the nasty, healthy feeling.
Well, you just
Hey, Fat.
You just chug it down. That's all you gotta do.
Hey, Cindy Lou. Yeah, I'm having chicken breast tonight.
You're eating chicken? I thought chicken made
Yeah,
you
I don't
sick.
like it, but I'm gonna try to do it in the air fryer. So I hope, but it's because I have to slim down a little bit. So I'm eating boring food for the next 2 weeks.
Okay.
This is banana money, not breadstick money. Thank you, Legendary.
Thanks, legendary.
That's from that tonsil twins case.
Okay. I haven't even watched any of that.
It's a weird one. She she had submitted proof of her pregnancy, and she had a doctor's appointment. And then we were looking at it. Yeah, the dates kind of checked out, but it didn't really say what she had done. And then we found out it was a CT scan of her head. Hey, Mom of 10.
Good one.
No. Hey, Maria. Be a little lurker. Yeah. Well, I only eat beef, fed beef. Your BFF is allergic to bananas. She gets all itchy. It was one of those things when she was like, "Do you guys get itchy when you eat the bananas?" And everyone else at the party is, "No." Well, my mom, well, shouldn't talk about that. She got clogged up whenever she ate them. So if where everyone else ate like Imodium or something like that to try and get a holiday stomach in order, she just ate a banana, and then that was fine. Are you all hungry or something? I'm always hungry.
No, I just ate breakfast. I'm good.
Pineapple for you, you get an itchy tongue. That's because pineapple has a flesh-eating enzyme in it, so that's why it itches your tongue. I know. Nope, I'm not putting that one up, Zach. You're allergic to coconut. Nobody is allergic to coconut. I'm weird one, internally and externally. I hate the taste of artificial coconut.
Ugh, I hate coconut. Anything.
No, I like a Bounty bar with coconuts in it, and I like when I made
Bounty
these cake.
bar?
Yeah, Bounty bar. It's a coconut. It's kind of like coconut shavings in a some kind of mix with sugar and stuff, and then coated in chocolate. It's real good. You should try it.
No, not a fan.
Everyone.
Yeah,
love
pretty
coconut.
much.
New video up on Fedorowski's channel. They will film another one tonight as well. Thank you so much. If one of the mods can get the link for that, that will be appreciated. Everyone, if you have nothing else to do tonight and you just want to relax, Fedorowski is the place to go watch.
He does have pretty videos.
Yeah. Yeah, that's my problem. It tastes like suntan lotion. Not that I know what suntan lotion tastes like, but the smell of was it Pittsburgh or what was the name that was real big back in the 80s? And when I was
Wow.
deployed, all the Polish soldiers used coconut scented suntan lotion. So when you were laying out getting a tan, it just smelled like someone spilled a gallon of Malibu.
Is it like the Hawaiian tropic? Yeah.
Probably, I don't know. It was really
I
bad.
love that smell.
Yeah,
Love
of
it.
course you do. Hey, Marshall. Bounty bars were your mom's favorite. I like coconut, but can't start the coconut flakes. I made a cake out of coconut flakes.
Yeah.
Yeah, I haven't had almond joy either. No. It's in the group of secondary allergies, so not the most common group, but next in line. Okay. Coppertone smelled like it. Probably Coppertone then. It was just. Ugh. What have I missed? And yes, I totally have a coconut and palm oil too. You have missed nothing. We have been watching this clock for exactly, it's 16 minutes, 18 minutes now, and nothing have happened. There was some audio and the camera shook and nothing else has happened. Yeah, go check out Fedorowski's channel. It's Norway is a beautiful country. It puts the lime in the coconut. No, but I don't know what's going on with this case. They are never on time, and they started at 10 o'clock today instead of the normal 9 o'clock. And it was supposed to be a half day, but then they said yesterday motions all day. But again, I don't think we'll go more than an hour when we start going.
Yeah. She's always cutting it short anyway.
Yeah, because she really don't want to hear about it.
Yeah. Bev is the worst.
Shout out to the Hawaiian traffic models of the 90s. They still exist. Maybe they still exist. I don't know. I bet you couldn't do those commercials anymore. But yeah, they were fine ladies.
That's funny.
Well, basically, she's doing a 4-day week. And I bet you she will be one of those judges who go 10 to 4 with a big lunch break. This clock is okay, but do you remember the seal of the state of Wisconsin from the Brooks trial? That was my favorite. Yeah, that's the one with the weird beaver platypus on it. Am I right, Jamie? Yeah, that's Wisconsin, right? Jamie doesn't want to talk to us now.
I don't remember.
Someone sent me the seal of Wisconsin, I think.
Yeah, I don't remember. Was that the one we were arguing about? If it was,
Yeah, if it's a beaver or a platypus.
Oh, yeah.
Hey,
But it
Lolita.
was like a badger was what it was?
No, it was a platypus.
Okay.
We are having a great day. We are just sitting here waiting.
Mm-hmm.
If you didn't want to be in court, then why should judge? Well, the pay is pretty good, I think. The Texas seal is the best. I don't even know how that is.
I don't remember that one.
Hawaiian Topic and Dumb Dumber. The girl is Swedish. Isn't it the Swedish bikini team that asked them to be the oil guys?
I don't know. I don't know. I remember that scene, but I don't remember who they were.
I think it was the Swedish bikini team. And I didn't know Sweden had one of those.
Do you like them better now?
No, because they're Swedish. Then Jamie, you don't know how it is. We have been fighting Sweden. We have been at peace with Sweden longer than your country has existed, and we have fought them more than. I think we're one of the nations in the world, two of the nations in the world who have had the most wars between each other. And they're cheats. Yeah, I know. It's the hard truth, but
I'm so angry.
that's how it is.
What?
I'm just trying to show something. Now we're talking about state seals and stuff like that. We have nothing
Yeah.
else to do, so we can do this. This is the state seal of Denmark. This is the big state seal. The part in the middle is the small seal. But that's our national seal.
Yours is just as weird as everybody else's. What's on
No,
there?
it's not, because it's the crown, and then it's the royal robe. Then you have the two wild men fighting for Denmark, and then you have our 3 lions and hearts. There's 9 hearts. I
Mhm.
believe these are for the first one is for Denmark. Then you have Sweden and Norway, because they are ours. I better check it out. Left part, 3 lines represent Denmark. In the lower part of the 3 crowns, only 2 are visible, represented Sweden. Oh, so lower left part. What? In the lower part of the 3. No, yeah, this one, the 3 crowns is Sweden and Norway, because we own those. They just don't know it. But then we have the polar bear. That's for Greenland, and the ram is for the Faroe Islands. The 2 lions on top is from the Principality of Schleswig, which we used to own, but the Germans took it from us. So yeah. But that's the old one. Today we only use this part in the top left and bottom right. But this is the national seal of Denmark, and it's actually been used since, in kind of that way, since 1190 by King Knud den Store, or Canad, as you Yanks would call him. So another day, another history lesson. Isn't the top part supposed to be the rib cages? No, that's supposed to be Denmark's glory. Yeah, the new picture of the king and queen was released today. And there's a lot of symbolism, according to the press, about how united they are and equal. Yeah, every Danish guy has a 12-pack. And then we start drinking beer. And then we just have a beer keg. Yeah, but that's because you stole it from us. Because you know we are the leader of Scandinavia. Højden, Deuten, Beuten. No. Hey, Kim. Well, is it already Friday? Yeah, it's past 4 o'clock, so it's Friday your time. Happy Friday. You're in the future. And Sophia Starlin, good morning to you as well. Sorry, but Camilla is a homebreaker, in my opinion. Personally, can't call her queen. Jamie, what nationality am I?
Danish.
Am I British?
No.
No. That's just because normally I'm being told I'm Dutch, but Camilla is Queen of England.
Mm-hmm.
The Texas seal is a star surrounded by olive and live oak branches, similar to the emblem of Paraguay, which is interesting. Yes. I know the star, because it's the one-star state, Lone Star State. What do elephants represent at bottom of the seal? That's the elephant order. That's a very, very special order that the queen alone can bestow on, well, the king now can bestow on people. And there's only, I can't remember how many it is, and you must return it to the royal house when you die. It's something you give to foreign dignitaries or politicians or people who have done something special. It's like in England they have the Order of the Garter. When it's a very, very, very prestigious thing to get in Denmark. But because it's so special. And I think maybe it was King Christian the Fourth who made it, but it's very specific. You can only wear it on certain occasions, and you must return it when you die. It's only worn if you are in full gala, so a black tie events and stuff like that. I do have a beer keg. I'm a chopster because pounds move pounds.
You
She
are
can't.
not.
Well, I am.
You are not.
Oh, on the new Discord this Sunday on the 28th, there will be a movie night. I won't be there because it's midnight my time. No one thinks of me, but I think all of you should join Jamie in there because Jamie will be there with her popcorns, 3D glasses on, and ready to rock.
That's what I do.
No, we have a king and queen too. We just got a king. His mom abdicated in January. That was a weird day. She's been the queen. She became queen 5 years before I was born. And when I was in the military, I was in the Marine marching band. So we saw her all the time. I have yeah, it's just weird. But and once I've been in Copenhagen and in Tivoli, our amusement park over there, and we've been at some fast food restaurant to get some food before the kids and I were going home with the train. And we were stopped outside Tivoli. She just jumped out of one of her cars and went in. She did a lot with the ballet, and so the kids were, oh, we saw her up close. Yeah, that's the fun part of living in our part of the world. We can get real close to the royals. It started. It was supposed to start 27 minutes ago.
Yeah, I don't know what they're doing. Come on. Oops.
Yeah, it's a great picture. Yeah, it was supposed to be at 10. Hopefully, you have some family that'll do it. But you have
They-
to. You can't pawn it off. You can't do anything. You must return it. Pounds break chairs too. Yeah, I've broken a few chairs. This one is real squeaky. The Danish Emerald Pearl is pretty snazzy. Ah. I was just happy when I saw the movie that we went back to a no nonsense action movie. But there's no elephants in Denmark. Did they steal them? Actually, Denmark used to have colonies both in India, Africa, and in the U.S. The U.S. Virgin Islands were bought by America from the Danes in, I believe, 1917. Saint Croix, Saint Thomas, and Saint, can't remember the last one. Saint Helene, maybe? No, Saint.
Hmm.
I can't remember the last one. Were Danish islands that we sold during the First World War because you needed them for naval bases, and now you turn them into tourist paradises. You fooled us. You're just like the Norwegians who stole our oil. They are letting people into the courtroom. Thank you, Peter A. Oh, normally you can't see movies about planes when you're on a plane. Yeah. Yeah. The Norwegian king is a cousin to our queen because when Norway finally broke free of the oppression regime of Sweden, they should have returned to Denmark because we were a kind overlord. But they chose to get one of our royals instead. We had a few lying around, so we chucked one of them on a boat and sent him up there. So actually, their royal house is the Danish. So technically, we own Norway. Hey, D. Robertson. Yeah, she was a lovely woman. Hey, before I go, so good to see you.
Yeah. How are you feeling?
movement. Sing choir. Yeah.
Peter did say that they were just people were coming in, so that's why it's taking forever.
So good to hear, D. Robertson. It worked. And I have an Instagram profile. You are more than welcome to put it up there so I can see if I can offer you any suggestions. Because sometimes you can tell if it has risen enough and stuff like that. I also have a recipe section in my Discord if people want to go in there and get some Discord, some recipes. Oh, that's not what I asked for. This is the seal of Norway.
Sorry, Marissa.
Well, I tried to be a history teacher once. Hey, Puddle. Yeah, we did, but then we gave you a king. He's not a drunkard, but how do you become a queen? Well, our current queen went to a bar in, I think it was Sydney or Hobart. No, she's from Hobart, which is in Tasmania. Any Aussies here can tell me. And she went to a bar at the around the time of the Sydney Olympics, and our crown prince was down there. He was participating in some sailing event, and they started talking. And 7 or 8 years later, she was the crown princess. Oh, it's the set of emerald crown jewels here Queen is wearing. I've seen all of the, because you can just go to a castle called Rosenborg Slot, where you can see all the crown jewels. They are displayed there. But to be fair, I don't know enough about jewelry. That's Jamie's department. She will study Danish royal jewelry.
Will I? When I buy my jewelry off Shein for like $1?
Yeah. Hey, Jackpot Springs.
I'm not really the queen of that.
Oh, sound.
All persons having business before the Honorable Federal Economic Justice of the Norfolk Superior Court, you public come here. Come in, give your attendance, you shall be heard. By the state of the Commonwealth of Massachusetts, code now open, may speak.
Commonwealth versus Reed, 2282 CR 117. Can I have the Commonwealth identify themselves for the record?
Adam Lally for the Commonwealth. Good morning, Your Honor.
Good morning, Mr. Lally.
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin. Good morning, Ms. Gilman.
I'm sorry. Good morning, Your Honor. Alan Jackson on behalf of
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
And good morning, David Unetti for Karen Reed.
Good morning, Ms. Giannetti. Good morning, Ms. Reed. All right. So, Paul, can I see? Thanks. All right. What I want to start with are motions that were either allowed by agreement. I just want to make sure our record's completely accurate. And if it's not, it's my error. So motions that I have that were allowed by agreement. I may need to take 1 minute.
Why is she laughing? She just came in. She needs to take a minute.
Jim, I'll be right back.
What the F?
She's the
She's
worst.
35 minutes late. She's 35 minutes late and she has to go back. What the F is going on, Jamie?
I don't know.
You got on Tom's stream yesterday morning for a few minutes. I was with Scott in Leominster. Yeah, was it Scott McGinnis who was on camera yesterday?
Yeah, he has been, but that was the first time I seen him too. So
Yeah.
shout out to Scott.
All right, thank you. So, allowed by agreement or previously allowed by me. The
It shows
motion
heavy
eliminate to
breathing,
admit the
man.
911 call, was there an objection to that? It is paper number 298.
There was no objection.
Yeah, I have that as allowed by agreement, so, okay. The motion for the court reporter, 291, and impoundment of what is supposed to be impounded, that was allowed by agreement as well, correct?
Yes, Your Honor.
What?
And Commonwealth filed a motion regarding Zoom as opposed to webinar, and that was allowed by agreement as well, 292.
No objection.
And motion to allow in-court identification, paper 294, that was allowed by agreement as well.
No objection.
Okay. Motion eliminate to admit the victim's photograph. I have not seen which photograph you're using, but you're in agreement that about the photograph. Is that right?
Yes, yes, that won't be an issue.
I have it as allowed by agreement. Are you using one or more, or have you not decided yet?
Just one, Your Honor, and I provided counsel with a copy of that as well as some other
Yep.
things today.
Okay.
Please
By
show
agreement.
everybody the
All right,
picture
thank you.
because it's not gonna
295, Jim?
help you.
Commonwealth's motion eliminate to admit photographs of Mr. O'Keefe's injuries during the autopsy. We had a lot of discussion with jurors about this. This motion is allowed by agreement,
Correct.
correct? I'm sorry, that was 296. So Commonwealth's motion eliminate to admit the paper number 307. I believe this was
Jury has been seated. Today is motions.
allowed. Commonwealth's motion eliminate to admit defendants out of court statements for purposes of medical treatment and certified medical records from the Good Samaritan Hospital. The notation that I had written on this was that the defendant has no objection to the admission of statements made for the purpose of medical treatment and medical records. The court takes under advisement testimony regarding the blood alcohol testing because that's a separate issue, and we'll address that today. Is that your understanding of where we stand with this motion?
Yes, that's our understanding.
Yes, Your Honor.
Okay. Jim, that was, I already said that, right? 307.
Yes, thank you.
The use of leading questions on John O'Keefe's young niece and nephew, we'll see where we stand. I think I said to Mr. Lally, jurors would rather hear from the witness than the lawyer. So let's see how it goes. And if you think that you need to switch to leading questions, please just come to sidebar. I'll give you the leeway you need, of course, based on the child's testimony or child's manner of testifying. All right, so you were both in an agreement on what I have is 316 and the defendant's motion number paper 288 regarding any reference to Aiden Kearney, aka Turtle Boy, or his pending criminal charges for witness intimidation. So both parties have agreed to not introduce this in evidence in their case in chief. If anyone opens the door, the motion will be revisited. And I think I said that I sort of disagreed with you both. I do think if witnesses testify to this spontaneously, then it comes in and it can be pursued further, but just come to sidebar. All right, 312, Commonwealth's motion to preclude reference to any bad character or any prior misconduct of the victim or any witness. That was allowed by agreement, Mr. Yannetti?
Do you know which motion we're talking about? Oh, yes. Oh, no, that's agreed.
That was 312, Jim.
Thank you.
313, motion eliminate to exclude character, reputation evidence of the defendant. You're not putting in reputation evidence, right? We talked about this, Mr. Yannetti?
This is a motion to exclude good character evidence. Is that
It's paper number,
by the Commonwealth?
it was filed by the defendant, and I questioned whether you intended to put in character evidence, and you told me no.
That is accurate.
Okay, so that's allowed too, Jim.
Which one was that?
313, let me just check.
That's a Commonwealth one.
It is. Commonwealth's motion It's 313, other Commonwealth date stamped, I guess, or date stamped 23.
Thank you.
There was no objection to the Commonwealth's motion to eliminate.
It will be even more claustrophobic because it's a smaller courtroom they will move into.
To introduce certified records from the registry, correct, Ms.
Correct.
Giannetti? Okay.
Correct.
All right, and then motions that perhaps were not agreed upon, but I previously ruled on. So, or I think I ruled on them. If not, these are my rulings. 297, Commonwealth's number 7. Commonwealth's motion eliminated to preclude reference and redact the manner of death contained on the victim's death certificate. And I think I said in open court, this motion is denied as to cross-examination of the medical expert, but that undetermined language will not appear. That'll be redacted from the death certificate. You'll have the live witness here to cross-examine us to that. So, Jim, that's 297.
Yes, Your
Honor. Commonwealth's motion eliminated to prohibit reference to any federal investigations, paper 317. Commonwealth bold stamp 27, to prohibit reference to any federal investigations conducted by the U.S. Attorney's Office and or Federal Bureau of Investigations. That motion was allowed after hearing.
They can't mention that.
305 is the motion regarding chalks. We'll address that when we address the defendant's motion. Regarding their audiovisual person. The third.
Turtle Boy will be brought up probably, and with this motion that they can't talk about a federal investigation and how some of those officers might be bad act, but they can bring in Turtle Boy. I don't think that's fair.
Party culprit. The ruling's clear on that. Not in opening. That's 320-30. I think that was clear when we talked about it. All right, so those are the ones that were fairly quick to just go through.
Yes, you can ask the medical examiner, what did you determine to be the cause of death? But you can't, it will be redacted if it's shown in court as on a piece of paper.
I've got another set that are sort of in the fairly quick range.
But she just ruled they can't bring it up. It's not like the other ones where they could bring it up during examination. Or if someone opens the door, but they can't, I don't know if she'll let them go fishing for it.
And then we'll move on to the Commonwealth's discovery type motions. So first, paper 284, defendant's motion for sanctions and exclusion of evidence based on the Commonwealth's failure to timely comply with discovery orders. Mr. Jackson, you told us at sidebar the other day that you are withdrawing that motion, correct?
Correct, Your Honor.
All right, so Mr. Clerk, that's motion 285, paper 285, withdrawn by counsel.
I'm sorry, Judge, 284.
Okay, I have it as 285. But
285 is the affidavit.
okay, yep, so 283,
Thank you.
withdrawn by counsel. Motion eliminate for review. So as defense counsel plainly states that a defendant is not entitled to be present at a view. And what I've determined here is that based on concerns for security issues and frankly distracting the jurors, the defendant will not be present with us on the view. And as you've stated here, that is well within my discretion.
Yeah.
All right. Commonwealth's motion eliminate to admit defendants out-of-court statements as statements of a party opponent. So I think that this was one of the ones that you all agreed to. Paper 308, 18 on the top. And it's followed by paper 19 regarding the various statements made to the media, to Boston Magazine, to ABC News correspondents. So I think the defendant had said previously that you were in agreement that all these statements come in. Is that right, Ms. Giannetti?
Sorry, Your Honor. Yes, that's correct.
All right. So I had a logistical question about, I don't know how long the ABC News interview is. How long is that?
Your Honor, what I can say is as to each of those, the Commonwealth's intention would be to play, to omit the entirety of the interviews, but to only play selected portions of those interviews.
All right, because what I did, I re-listened to the nearly 4 hours, 3 hours and 40 minutes of the Boston Magazine audio, and there's no objection to it from counsel. What I listened to, it made sense, and I didn't know how you would play a 3 hour and 40 minute audio. If you think you need to, we just need time to be able to put it into the schedule.
Sure.
Okay?
No, I don't feel the need to play the entirety of it.
We just
Okay.
need to play his pieces.
I was involved in a trial once where we watched a whole movie.
Oh, I wish
So
we could do that. If it's a good movie.
just give me a heads
Yes,
up if
it's
you
good.
think it's a lengthy segment. But how long is the ABC interview? Just in case counsel wants to go back and fill in.
I think the portions that we have are not terribly lengthy.
Are they terribly or
And as far as the statements are concerned, it's even less of that.
All right. So does defense counsel intend to also play I'm trying to find out if we're going to need a whole 3 hour and 40 minutes. I need to know that. I still haven't got an answer as to how long the Dateline or ABC, whatever it was, video and audio is. How long is the entire thing? Do you know?
You're asking me?
Either of you. I don't have that. So I didn't review it.
May I have just a moment with
Yes.
counsel?
Of course, they're cherry picking.
Well, yeah. I mean, why wouldn't they? That's what they do. I mean, they both do it. Both sides do it.
Free Willy, yeah.
My memory and my belief is I think, and I can't recall specifically which one is one or the other, but I think one is about 10 minutes long, the other is about 5 minutes long, and again, I would only be playing, if any, portions of the defendant's statements, not the entirety of the broadcast.
Okay.
And if there are portions that weren't played, I would expect.
So that's what I'm trying to figure out. So I'm concerned on the 3 hour and 40 minute one, which seems to be all of it's admissible. There's no objection to it. And if, I just need to know if we're going to play something for 3 hours and 40 minutes. The other one, if it's 15 minutes, I don't need as much heads up.
My guess would be anything that we would want to present that wasn't presented would be in the 15, 20 minute
Okay,
category.
that's
Not
fine.
3 hours.
It's just for scheduling purposes. All right. So, Jim,
Yes.
paper 309 and 308, they're the same pretty much. Those are allowed by agreement.
Okay.
Don't yell if we can read in the courtroom. Be the better side. Don't do that. I hope it wasn't what they said.
All right. And it's sort of in the same vein. So it's another statement of the defendant. It's the statement of the defendant at the Milton State Police Barracks
No, please.
that I had not seen before because it was post grand jury. And we watched it. I had the opportunity to watch what we all watched here in court last Friday. And over the weekend, I watched the entire hour and a half or so of it. So you're in agreement that the statement comes in, and the Commonwealth says that the Commonwealth needs some leeway to show that she was in custody after arrest for a period of time, and Commonwealth wants to play the video. I don't think we need the video. Much of it is just looking at their computer. So the video
Oh,
part will be out. You don't want it in,
I
correct?
saw them.
That's correct. We had
Yes.
asked for the audio only.
Yeah. Okay. So the audio only, but it needs some context. It's not just that she's sitting down having a cup of coffee with the police and makes these statements. So they're clearly voluntary, clearly unsolicited. How do you want to work that out? Can it
And
be
they're
that
clearly
this
so
occurred at the Milton State
irrelevant
Police Barracks on a particular date?
to what
Because if
said
you
it
can't
was.
work it out, then I'll decide it.
Why is her voice a mixture of annoyed and I'm reading a smut audio book? She's so
Well,
breathy.
her breathing into the mic and like just is so annoying to me. It's like she could, like she's out of breath, but also she could care less. It's a lot of stupid.
Yeah, and she has a very good directional mic. But one of the things you are taught very soon when you Google how to use a mic is don't talk into the mic, talk past the mic.
Mhm.
Well, Federowski will probably tell me that's wrong. She has a Yeti cup, Jamie. She's your BFF.
303?
Yeah, I mean, from our
We're not
position, Your
friends.
Honor, we don't object that the statements were made at the Milton State Police Barracks as they were. And it was in that context that she was speaking to the police at the barracks. We would object to introducing evidence that she was under arrest at that time.
Yeah, I don't think we need that. But so at the Milton State Police Barracks on a particular date.
That's acceptable.
Do you need more than that, Mr. Lally, for context?
No, Your Honor.
Okay.
I
How
just
is this
need her to
going
say
in?
This thing that is
Through the trooper to whom she was speaking.
Okay.
so stupid.
All right.
That's fine.
All right. So, Mr. Clerk, audio only. Commonwealth,
Janetti is
illicit,
the little older.
testimony. Statement occurred at the Milton State Police Barracks. Still, Allie, do you remember the date?
June 9th, 2022.
Thank you.
22.
Yes.
Okay. So audio only, Mr. Clerk. Commonwealth may elicit testimony that the statement occurred at the Massachusetts State Police Barracks on June 9th, 2022. All right, so those are the fairly quick ones. Before we get to what I think are the more complex ones, or the ones that I need a little bit more argument from you on, I am concerned about discovery. So, Mr. Lally, when I was going through copies of what I had previously, the first time or one time that Commonwealth filed on March 21st of this year, a notice for reciprocal discovery and notice of experts. You then, last week, I think, filed a renewed motion for reciprocal discovery and request for voir dire of any defense experts. You asked that that be impounded. And that will be based on your motion and appears to be sort of an affidavit in support. So where do we stand with discovery?
So with reference to the reciprocal discovery, what Commonwealth is seeking is noted there are a number of witnesses listed on the defendant's witness list with no materials provided as to who these people are or what their intended testimony is. The issue with regard to experts is essentially there are 5 experts. Mr. Green, who there was an attachment to a motion with an affidavit and some materials. I think I have everything in relation to that. With regard to Dr. Sheridan, I have an affidavit and a curriculum vitae, and that's essentially it with respect to that. I just am inquiring as to whether or not there are any reports or any other sort of findings or anything post that. The other three experts all relate to that specific, I'm sorry. The next would be Dr. Van E, who...
Which, I'm sorry, I didn't hear you.
Dr. Christopher Van E.
Yeah.
I'm a little... so essentially there are that gentleman and then three individuals from this ARCA company.
Why is she sounding like she is bored out of her mind?
I know.
She's a
And he's doing
judge
it
in a
too.
high-profile case.
Mm-hmm.
What the F is going on with this woman?
And the way he speaks too, it's just like this is such a nuisance to them.
Yeah, they are about to determine a woman's life, and he's smacking his lips, and she's breathing like I shouldn't say stop that.
Who are all purported to be testifying in the area of crash reconstruction. None of them are crash reconstructionists. They're all biomechanical or biomedical engineers. With regard to Dr. Van E, who I've had some experience with in the past, my typical dealings with him is there's some sort of report written by him. I have nothing. I just have a CV and about a paragraph of what's anticipated as far as his testimony. The other three individuals, my issue is there is a report that's within the federal materials in relation to what they did. However, it's a single
In relation to what?
In regard to whatever examinations or tests or whatever that.
Does it include all three experts though?
Well, so that's the issue.
Yeah.
The issue is the report is signed by all three individuals. So I have no idea who did what, who would testify to what, who has an opinion as to what, or what that would be. So I'm just looking for some additional information or any.
So this is these care guys or whatever CAS guy. They just picked them up after the feds used them to make their report. That's interesting.
Clarification as to what each of those respective people would be testifying to beyond just all three signed a report.
Okay, who's arguing this for the defense?
With the court's permission, I'd like to handle the issue regarding civilian witnesses and have Mr. Jackson address the experts.
All right.
So my argument's very brief, Your Honor. We're well aware of our obligations under Rule 14, and any statements that we have regarding civilian witnesses that fall under that rubric, we will turn over, and we have.
But why haven't you?
No, we've turned over what we have. So in our view, we've complied with discovery with regard to the civilian witnesses that Mr. Lally speaks about.
All right. Do you have addresses for those witnesses, Mr. Lally?
We did it. Yeah.
All right. So they need addresses, right? If there's nothing there, they need the addresses so the police can go out and interview them.
We will get them addresses by the end of the day today.
Dave, they are ruling on motions, and on Bev is sounding like this case has been going on for 20 years, and she's dead tired of it. And Lally is smacking his lips as he's expecting a big piece of candy when he's done.
Okay. All right. So my concern was that when, Mr. Lally, when did you file your certificate of compliance?
That would have been, I believe the Wednesday, not last Wednesday, the Wednesday before that.
And I had previously told counsel I would expect within 2 days of that, because obviously you've been preparing this case for a long time.
Of course, yes.
But so to have Mr. Lally stand here today.
Oh my God.
He doesn't have all this information that he's entitled to.
Yeah, I love she's telling the defense, why haven't you done it yet? Lally has constantly lied to her about deadlines.
Well, why is she yelling at them about when he took him like a year and a half to turn over DNA evidence?
Yeah. Yeah, well, it's done in 6 days, Jamie. Maximum 2 weeks.
Okay.
Dates of birth and addresses of witnesses are pretty standard, Ms. Giannetti, especially if you have, not provided anything that they're going to say. So that should have happened a week ago.
Oh my God, shut up.
If I may defer to my co-counsel.
Well, okay. And we do have to talk about how we're going to do this at trial. Okay.
Yes.
Your Honor, I provided reciprocal discovery to Mr. Lally within 24 hours of receiving
Okay.
the certificate of compliance.
Anything about these witnesses that Ms. Giannetti says they have everything on?
Yes, he's received statements from all the witnesses that we have statements for, which included their dates of birth, addresses.
How
all
many?
that.
How many is that?
Why are you constantly stopping her? You ask her a question and then you start asking. What she's telling you now is Lally just lied to you again.
Yeah.
And you're taking it on the nose and saying, well, I'm going to protect poor little Lally. This is infuriating. It's the wrong day to stop sniffing glue.
Little. How many witnesses?
I don't know off the top of my head, but every single report that we have for these witnesses that Mr. Lally has received in his witness list, he has reports for.
Okay.
And a number of our witnesses, obviously, are witnesses that the Commonwealth has interviewed.
Right. I think I crossed out much of your list when I read the names of the witnesses, right?
Exactly.
Because they were duplicates.
So we have complied with at least those obligations. And if there's any addresses that we haven't produced, I will make sure that gets done today, but he
Thank
should
you.
have the vast majority of everything.
All right. Anything specific, Mr. Lally, on the civilian witnesses?
Well, just in looking at the defense witness list, there are 77 witnesses that are listed. 35 of them are on the Commonwealth's witness list, and I have statements from 4 witnesses, not including experts, so that would probably make it to 9, or if you include the investigator, 10 or 11. So there's still a substantial amount of witnesses that I don't have addresses, date of birth, or any statements from, or even what their anticipated testimony would be.
Your Honor, there's also probably an additional 10 to 12 witnesses that he has reports for from the federal materials, which include addresses, statements, that type of information.
All right. It's my view that that's still the defendant's obligation to provide. All right. Or at least acknowledge where they are. All right. Now let me hear.
So because he's an idiot that can't use the same reports the defense is using, they have to tell him you're an idiot, that the reports you already have has the address on it.
Yeah. But Judge,
It's burnt
I
toast.
have to look at more paper.
Best time Jamie got a message when she was just about to make fun of
Jeez,
Beth. No, but again, why is it the defense obligation to tell him it's already in your paper, idiot? So she should just say, Mr. Lally, look at the reports that the Federal Bureau of Investigation provided for you. All the addresses are in there. The rest of the people we talk to are your witnesses. So you do have all the names and addresses because it's your witnesses. And could you please run into a wall real fast?
the expert response, Mr. Jackson.
Your Honor, with regard to Dr. Vanny, Chris Vanny, first of all, he is technically a rebuttal witness. There's a trooper named Trooper Paul that's going to be called in the Commonwealth's case in chief, and he's going to testify to some key cycle information. Key cycles are trigger events or cycling events with regard to the SUV. Chris Vanny is expected to testify in rebuttal to Trooper Paul's testimony that his Trooper Paul's analysis of the key cycles is flawed in terms of timing and the number of key cycles that he relates back to an event that takes the SUV back to 34 Fairview. So Chris Vanny has done a similar analysis, or at least overviewed or looked over Trooper Paul's analysis and has determined that Trooper Paul's analysis is incorrect. So
All right.
we included his name, although he's a rebuttal witness, we included his name just to be in an abundance of caution.
All
He
right.
has not produced a report.
Do you have to at least tell the Commonwealth what he bases his opinion on, what he has viewed, what he bases his opinion on?
The exact same information, the raw data that Trooper Paul based his opinion on.
All right. So is this the first you're hearing this, Mr. Lally?
There's kind of a vague description to that effect, but again,
It's a rebuttal witness. They don't need to go in depth with his testimony, idiot. There's a vague description. So there's a description. Sorry, people from Massachusetts, why do you pay taxes?
what I'm hearing is similar to that in the sense of he disagrees with the Commonwealth's expert, but I don't have any foundation for that or what specifically he disagrees about or what his points of contention would be with Trooper Paul's report as far as no report, no basis of opinion, no anything of that nature. That's my concern.
God, I want to,
Okay.
because you're
And you've requested a voir
floundering. That's
dire?
why. You're just so scared.
Yes, Your Honor.
Of
You
the
know, this is a
experts?
stupid case.
All right. We don't want to bring this witness out here early for a voir dire. So I suggest you get the information that was requested.
I'll be happy to.
If we have to bring him out, we have to bring him out.
No, I'm not looking to bring him out, and I don't think that he needs to be voir dired. He's going to look at the exact same, and I'll call Mr. Lally and explain to him what I think in a little bit more granular detail is going to be the sum and substance of his testimony. But Mr. Lally he certainly can conceive, as Trooper Paul walks through his analysis, Chris Van E is going to walk through the exact same analysis. It's the same data set. They're both working with apples and apples.
Opinion.
He just has a different conclusion that the key cycles are not in keeping with what Trooper Paul analyzed because he left some key cycles out. Pretty simple stuff. But
Yeah.
I'm happy to contact Mr. Lally offline and let him know exactly what it is that
All
Chris Van E
right.
has a
All
problem
right. So you do that. And if it's not resolved by Monday, we will pick a date within the next week to have voir dires of whatever experts that insufficient discovery has been provided to the Commonwealth on. So let's try and work everything out. The rules are very clear, and you need to provide this information.
And I thought we had, but I'm happy to have that additional conversation. And I'll do the same thing with regard to the ARCA witnesses as well.
So is there anything specifically, Mr. Lally, that you're looking for today in response to the biomechanical engineers?
Just specifically what their opinions are and what they're based on.
And who did what?
Who did what?
Should be fairly easy to provide, Mr. Jackson.
It has been in about a 9 or 10 page report that's detailed,
Yeah.
single-spaced.
But does it say who did what? I read the report as part of the federal materials. I couldn't figure out who did what. So,
Okay, I'm happy to talk to Mr. Lally about that. I believe the answer is going to be, in sum and substance, all of them work together as a team to come to the opinions and conclusions that are recited in the report. But I'll be happy to have an additional conversation with Mr. Lally about that. I don't know that I know every single thing. As a matter of fact, I don't know every single thing that everybody did. Who screwed what bolt into what nut?
They had agreed on a lot of the motions. Turtle Boy can only be brought up if someone opens the door. It's okay to talk about prior bad acts. That's the Rupa thing. They can't talk about her personal reputation. They can't bring in positive evidence of her reputations. Talking about the kids will be on. Let's see how it goes. They can cross-examine about the undeclared death, but that will be redacted on the death certificate. They aren't allowed to mention the federal investigations. Karen won't be with them at the view. The interview from the media is allowed, but if they're going to run longer segments, they need to tell the judge. The arrest video will be audio only, and it'll be some kind of milk toast, that's the word, description at the state police barracks at this state. And now we're discussing reciprocal discovery. Lally wants the experts reports. He already have them because it's in the federal material, but they are not crash experts, even though they are specialized in crash scenes. And then he wanted a report from an expert where they told him, well, it's a rebuttal witness. It's not a fact witness. Yeah, but I want to know what his report is based on, and it's the same data as the state. And the 9 pages report from the federal from the feds is a team job, so he can't tell exactly who did what. Everything up to this, and now you have time to chill,
etc. But I think by and large we can Mr. Lally and I can come to an agreement about what the contours of each of their testimony would be.
Oh, and Lally wanted
And by the way, they
addresses
are
on his own
accident
witnesses, apparently.
reconstructionists, so there's a.
Do you have their CVs?
I do, and so does Mr. Lally.
I do.
Anything on the CV about being accident reconstructionist?
There is listings of accident reconstructionists, but I think that's part of the Commonwealth's request for a voir dire is the qualifications. I don't think meet that standard for them to be able to testify in that area.
All right, so two things. When the two of you were working on this between now and Monday, if the Commonwealth is not satisfied in requesting a voir dire, I need to hear from the two of you whether we need to do that before the evidence really gets started, or if it can be done before the witness testifies.
Okay.
All right.
Understood, Your Honor.
I'm pretty sure he didn't understand it anyway.
No, he didn't. He's whining because he knows he's gonna get blown out of the
All
water.
right. So Commonwealth's motion for voir dire of any witness to be asked for opinion or character of defendant or any witness. I had that this was allowed by agreement, 314, Diaz number 24.
That's agreed.
And 304, Commonwealth's bolded number 14, Commonwealth's motion for order regarding opening statements and notice of any visual aids defense intends to display to jury during opening statement. So I need to know what parties intend to put up for exhibits or for chalks, whatever you intend to put up.
We pulled up the company. It's a company that specializes in crash reconstruction. Yeah, but they're biomechanic engineers. It's probably better than the expert working at the police department.
Yeah.
Up an opening. And I know you're doing the opening, Ms. Gianetti. So I need to know what you intend to display.
Nothing.
Okay, that makes it easier. So while we're talking just briefly of openings, you had told me, Ms. Gianetti, that you thought you could get everything in 35 minutes. I will give you both 45 minutes.
Oh, that's perfect. Yes, I'll be less than 45.
I'll hold you to that.
I know you will.
All right, so Mr. Lally, 45 minutes for the Commonwealth?
Yeah, sure.
Okay.
So he'll go for an hour.
Yeah.
All right. And Commonwealth, do you intend to put anything up during?
No, degrees doesn't equal areas of expertise. Exactly. And they work with this. But now we're going to voir dire and say, yeah, we've done this 1,000 times. No, it's not. It's a company that works for the FBI. Always. I can't remember the name of the company. We can bring it up later. Is it
During
DACA or
openings?
During openings, no, Your Honor.
All right. Okay. Commonwealth's motion eliminate for notice and voir dire of Bowden. I thought that was, we decided that there would be a voir dire regarding before the Bowden testimony comes in.
I don't recall that, Your Honor.
All right. Well, Commonwealth's entitled to a voir dire. There'll be a voir dire.
My understanding of the court's ruling, as it applies to opening statements, is that I cannot point the finger at a third-party culprit, but I can introduce the idea of an inadequate investigation and discuss Bowden evidence.
As long as you know what's coming into evidence.
That's perfectly fair.
Remember, I use that term competent evidence.
Of course.
That's what it has to be.
Of course.
All right. I'm sorry, Jim. 321, the Commonwealth's bolded 31, in case my number's not right.
Thank you.
319. So this is, we talked a little bit about this. It's Commonwealth's motion for advance notice if defendant intends to cross-examine any witness about alleged bias and request for pretrial ruling on whether the proposed evidence demonstrates a plausible showing of alleged bias. So as you well know, Mr. Lally, bias is definitely an area that is ripe for cross-examination and extensive cross-examination. I needed to know exactly what your concerns are.
They can't cross-examine.
And Your Honor, I think what I would suggest might make the most sense with this is to sort of take it as it comes.
Okay.
I think it's a little difficult to put counsel in a position to, cite specific things that they wish and
we have a couple of motions where we do need to do that.
Right.
But for generally with this, and because this was broad, that's why I did want to when we had a brief hearing on this, I said that I did need to hear from you regarding specific statements. So what we're going to endorse this, Mr. Clerk, is that Commonwealth will object on a question-by-question basis. Does that work, Mr. Lally?
Yes, Your Honor.
Does that work for the defense, Mr. Yannetti?
For sure.
Okay.
Commonwealth will object.
Commonwealth will object to specific questions.
Thank you.
And Mr. Lally, if you know in advance, depending on how the testimony comes in, if a particular witness gets up and you know before any examination what your concerns are, we'll visit it before the testimony.
Understood.
Okay?
Thank you, Your Honor.
A similar motion to the defense expert issue. Mr. Clerk, I believe it's 315. It's bolded number 25 from the Commonwealth. Commonwealth's motion eliminate to prohibit defense experts from testifying regarding scientific studies or anecdotal experience and request for voir dire. Mr. Jackson, do any of your witnesses intend to give anecdotal experiences?
I said this in the argument. I don't really know what that means, but no, in terms just the common sense knowledge of common sense definition of what that is. To my knowledge, they're not going to be talking about any.
Okay, I think it's pretty clear what it is, but if you think they're not going to do it,
It's not pretty clear because everything is an
God.
anecdote. Because if you're asking, have you ever seen a guy lying outside in the snow for 6 hours only lose this amount of temperature? And they're not allowed to draw on scientific material or anecdotes. How can they answer that? Say that's stupid. It's pretty clear. No, that's they're experts because they know anecdotal evidence and scientific evidence. This is stupid.
if it seems that they are, then we need to know. And how about the scientific studies?
Scientific studies would not be referred to in any of their testimony that I'm going to elicit at all.
Okay.
They did some scientific studying of the material.
No,
obviously.
do you mean like learned treatises and things like that, Mr. Lally?
Exactly, Your Honor.
Yes.
They're not going to be citing to learned treatises that I'm going to elicit.
Okay. All right. That's it in my category of discovery. There's some overlap in the motions that I think the following motions may take a little bit more time, and it's sort of the somewhat complex ones. So 311, Commonwealth's bold number 21. Commonwealth's motion eliminate to admit the victim's out-of-court statements relating to his state of mind. There's sort of some overlap, Mr. Lally, that we'll get into with other statements. But so this is the Commonwealth versus Qualls, Commonwealth versus Binns, that whole line of cases. Why don't I hear you? Is there any objection to this?
We may have a moment, Judge.
The Commonwealth, we were here last, the Commonwealth was told that they need to provide with the statements or the areas they intend to introduce. They do so in this motion. They do more extensively in another motion that's sort of dovetails. And the other motion concerns the Aruba incident, the arguments between the defendant and Mr. O'Keefe, and also this Binns/Qualls type testimony.
Right, so I think our position, Your Honor, was that we need to know the specifics of what they intend to introduce. My expectation is that some of that will be admissible and some of it we won't have an objection to, but it's difficult to give either a blanket objection or a blanket assent without knowing the specifics.
Okay, but you did sort of make a blanket objection to the Aruba incident, if we call it that.
We had to without knowing the specifics.
So on the second page,
Yeah.
Notice this. She didn't instantly say, so Mr. Lally, you will provide that. She did that when he asked for exactly the same thing from the defense.
Mhm.
She again cut him off and said, by this to the second page.
of this motion, the Commonwealth intends to introduce statements the victim made to his family members and friends close in time to the murder about his relationship with the defendant and his decision to terminate the relationship. The Commonwealth also intends to introduce the victim statements through text messages authored by the victim and contained within the victim's cell phone that express his decision communicated directly to the defendant to terminate their relationship. That goes squarely with Qualls and Bins.
Right. With regard to the text messages, I don't believe we have a basis to object.
All right, so I'm also going to allow statement. Mr. Lally, tell us what the statements specifically, as best you can. Who would be testifying? What family members? Does this involve the two children?
Yes, Your Honor. So there are statements that are made by the victim to the defendant in front of each of the two children with his intention to.
What are they roughly?
Essentially that the relationship isn't working anymore and that he would like to break up with her, ask her to leave the house. She refuses, and this is in front of both the niece and the nephew.
All right. Ms. Giannetti, I'll hear you on that.
Let's hear it. These were like little kids. Come on.
Our expectation is any statements that were made, allegedly made by Mr. O'Keefe to my client in front of other witnesses, we don't have a basis to object to that.
Okay, so that's coming in. And you've had the benefit of the sane interviews for a long time.
Correct.
Right, so,
We don't waive potential hearsay objections during trial, Your Honor, but I think generally that's our answer.
all right, so on 311, Mr. Clerk, I'm going to allow that.
Yes, Your Honor.
Okay. All right, so sort of the same. 310. All right, and the defendant's is 283. It's a similar motion. So, Mr. Lally, why don't I hear you on this? So this is the one when I said there are three areas here as I see it. If we call it the Aruba incident, the animosity between the defendant and the victim in weeks and days prior to the victim's death, and that the defendant admitted to numerous witnesses at different times that the last thing she recalls was getting into an argument with the victim. So that whole domestic violence line of cases with state of mind clearly is admissible. So why don't I start with you, Mr. Lally? Go ahead and argue your motion.
So, Your Honor, specifically, what the Commonwealth is seeking to introduce there is you have the incident in Aruba, which there are really four witnesses who have information to provide to the jury.
Do we need all four?
Well, so from different perspectives is what I would say. So two of them are, the incident or altercation occurs in the lobby of the hotel where the defendant, the victim, and the children are staying along with a larger party of friends of the victim. Following that incident, both children indicate that there's approximately 20-minute screaming match or something to that effect.
Both children were present?
Yes, within the hotel room, and both indicate to that. Then you have the woman, Marietta Sullivan, who's involved in the incident in the lobby, and then you have her sister, who is the person who invited them on the trip in the first place.
There's some additional testimony from these witnesses too, other than just the statements?
Correct. So the additional testimony from the sister who invited them on the trip, she's not a recipient witness to the altercation. I wouldn't be asking her anything about that.
Okay.
What I would be asking her about is just her observation. So she had gone out the evening prior with the victim and the defendant to dinner, and sort of the disparity between sort of their demeanor on the night before versus post this incident. And there was some statements that Mr. O'Keefe made to her about sort of the nature of their relationship, or the nature of his relationship with the defendant.
And those statements have been provided to the defendant?
Yes, sir.
There was testimony in the grand jury regarding those statements?
There is, yes.
I believe there was 6 and 9 at the time.
There's
Yeah, they were young.
state police reports as well as testimony from the witness and the grand jury. In addition to that, as far as statements relative to the nature of the relationship, there are some minimal statements that are made by the defendant to a couple of witnesses at the waterfall the night before. Again, those are also contained within troopers' reports and the grand jury testimony of those witnesses. There are also the text messages between the victim, Mr. O'Keefe, and the defendant, which specifically address the nature of their relationship. There are text messages from the defendant to Mr. Higgins, which again specifically address not only the Aruba incidents weeks later, as well as and being a continuing point of concern, at least from the defendant's perspective.
No, he had adopted his sister's kids. Both his sister and his brother-in-law died. He had adopted them. They want them in to talk about how their relationship was on the rocks.
As to the nature of their relationship. And then taking all of that sort of in conjunction with the text messages between the two that day and the voicemails, messages that the defendant left on the victim's cell phone shortly after the murder occurs. And then there are further statements that the defendant makes to a number of different people, whether they be troopers, whether it be paramedics, whether they be Ms. McCabe and Ms. Roberts, or in the presence of them, as well as at least 3 paramedics, indicating that the last time that she saw the victim, Mr. O'Keefe, they had gotten into an argument essentially at the house at Fairview Road right before she had left. So those are sort of the totality of the sort of specific areas in the nature of the relationship that the Commonwealth will be seeking to explore through the testimony of a number of different witnesses.
Okay. Who's arguing this for the defense?
I will, Judge. As I'm listening, there seems to be quite a few different categories of information that the Commonwealth is seeking to introduce, and through different means. So, it's difficult to, again, just give one blanket objection, one blanket assent to this. Generally speaking, witnesses who would testify about statements of Mr. O'Keefe's state of mind, that probably comes in.
We talked a little bit about that. That's the Qualls and the
Correct.
Bins line of cases. So
Correct.
I did rule that those are coming in.
We recognize that,
Okay.
yes.
You said probably.
Well, yes. Well, Mr.
right.
Lally raised it again, so.
And you don't have to assent. You can object to anything you want to object to, and I make the call. I mean, so you don't need to point out, you don't need to apologize for objecting. Just go ahead and tell me the defendant's position.
Right, I understand, Judge. I think the position here is that we recognize that much of this will come in, but we don't waive the ability to object to a specific question in terms of what it's, what it asks for, how it's phrased, what could potentially come in if the question's too vague. So that's my hesitation on that. That's
well taken. So even if you assent to it, doesn't mean that if a question crosses the line, you're prohibited from objecting to it. I've never done that before.
That's my point.
Yeah, so you haven't tried before me before. I would not do that. So I find that, let's say for the Aruba statement, all of these go to state of mind and motive. I will give a limiting instruction. I will make the findings that I need to find pursuant to Commonwealth versus Samir. It's a footnote in that case. It's footnote 8, I believe. I will make those findings at the time. There's certainly been a sufficient showing from the Commonwealth. So I will give a limiting instruction. I will welcome propose limiting instructions if you want to file them. I know you're all busy. If you don't want to, that's fine. I can handle that. Regarding the animosity, again, it's close in time. It goes to the nature of the relationship. I will give a limiting instruction. I'm confident that the limiting instructions will be followed by the jurors, that they're understandable. I will make observations at the time, and if they appear to be understanding and nodding, which you often see on limiting instructions, I will make those findings as well. But I'm satisfied that the jurors will be able to understand a limiting instruction and use the testimony only for the intended purpose. And the animosity goes to the nature of the relationship, goes to the domestic violence line of cases. And the argument being the last thing that the defendant says she recalled, and the children's testimony regarding ending the relationship, again, that goes to state of mind, and it goes to the Qualls and Bins line of cases. And I will give a limiting instruction. I'm confident the jurors will understand. So that's my ruling on that, which actually, so it would be a denial, Jim, of defendant's motion 283.
Just for the record, it's 282.
82. And that's
it's really bad to
denied.
see
I mean, it will
how
not go to propensity, and
biased
we can make
he is.
sure of that. And
That's why I'm saying right now, before we start, I'll give her a 60% chance of being found not guilty.
the Commonwealth's motion is 310, Jim, the bold 20, and
The incident in Aruba happened on New Year's Eve, so 29 days before.
that was sort of hand in hand with the other one. All right. So moving on to, I think we just briefly talked about, so it's paper number 306, Commonwealth's motion eliminate to admit expert celebrate demonstration. I think we briefly talked about it, and I wanted to know, so are the defendants objecting to the, so your witness's name again? I read it every day for the last week.
That's okay. It's Mr. Ian Whiffen.
Yes. So about him doing a demonstration, is there an objection to that from the defense?
Exactly.
Your Honor, thank you. Since the last time we were in court, we've had an opportunity to look at that.
Yeah, I'd like to look at it, but okay, so you looked at it?
We did. It's not that long. It's maybe, I don't know, I want to say 22, 25 minutes, something like that. We'll submit on the papers and stand on the objection that we previously made, that it doesn't comport with the exactitude that we think is necessary for a demonstration, but I don't think it bears. It's not an enormous deal for us. We do stand on the objection, but I'll submit on the papers.
All right, so I'm going to allow it, but Mr. Lally, I'd also like to see it.
Of course.
Okay, so if you could get me a copy, Ms. Gilman, can you get me a copy of that before the end of today?
I think so. Yes.
All right,
I'm
thank
speaking
you.
for.
Yeah.
All right, so Jim, 306 is allowed?
Of course it is.
All right,
I
so
don't know how
the
he looks.
two that may take, there's three actually, but the two that we'll cover here before we get to sort of logistics and sequestration. Commonwealth's motion to prohibit reference to any pending internal affairs investigations or unfounded allegations. And I did just, I don't know why, I know you filed it previously, Ms. Little, but I just today had the opportunity to read your supplemental memo in opposition. Okay, so, all right, so this is twofold. So I'll hear the Commonwealth regarding Trooper Proctor and also regarding Sergeant Lang.
Sure. Your Honor, with regard to, I think the recent sort of progeny of cases between McFarland and Graham are sort of entirely instructive. I would submit as far as this particular area is concerned. So when it comes to Sergeant Lank, you're talking about a civil case with no judgment. There was no finding. There was no trial. So I think Graham and McFarland are pretty clear that is not conduct that can be used in a criminal case to impeach a witness.
But why can't it be used regarding, I think what separates this in some respects from those cases, even though there's no finding, is just like the pure bias part of it, right?
there really isn't any cost effectiveness. And now this is prior bad acts from the officers that shows bias, and all of a sudden, no, we can't talk about that. But when the state needed to talk about prior bad acts, it's no problem with that.
If there's bias in favor of the Alberts, which is what the defendants say their defense is among the possible third-party culprits, why can't they cross-examine on that?
Well, the information that I've seen, I don't think specifically lends to a defense of the Alberts. I think if it lends to anything, it lends to Sergeant Lank being involved in some sort of altercation himself, in whatever extent.
It was an Albert starting a
There's
fight
any
in a bar.
veracity to whatever is alleged by the other parties to have occurred.
They sued the state and
Firstly,
won.
secondly, I don't even believe. Again, I think we're going to, one Albert equals the entire Albert family kind of thing, and I don't think that any of the Alberts that they point to, or at least that Mr. Yannetti got up and spoke about being potential third-party culprit targets, were even present, involved, or had anything to do with this prior incident. So whether or not Sergeant Lake knows or was 20 some odd years ago friendly with one member of the Albert family, or even two, if they're not any people that were at the residence on Fairview Road that night, that were present there in the morning when he arrived, pursuant to a call from a sergeant on scene to investigate, or anything of that like, I don't see how it's relevant to that form of questioning or impeachment, particularly where it's an unsustained finding and there's nothing, concrete as to what transpired.
Okay, I guess my question was simply because something might not fit squarely in McFarland and Graham. If it's admissible for other purposes, then it can come in.
Right.
So who's arguing this part? We'll take these in two parts. So we'll do the Trooper Proctor part afterwards. But there's little. I did say I'd give you the opportunity to argue those two cases, but if you want to, you can. But I'm more focused on the bias or motive.
I'll
part.
just briefly address Graham and McFarland, because
Sure.
I do think it's very important that we make clear that both of those cases are completely an opposite to the issue that's before this court, which is admissibility at trial. McFarland and Graham both deal with whether the Commonwealth has an obligation to turn over certain discovery. That's not where we are right now, right? We filed the appropriate motion to receive discovery. We obtained information about an IA investigation. We obviously—
But just let's focus on Lank first.
Sure.
Okay.
So-
I agree with you. They're discovery cases. They're not admissibility cases.
Okay. So that issue aside, Lank has he's one of the first responders, obviously, who went to 34 Fairview on the morning of January 29th. He's the first person to enter the Albert residence that morning. And he has a long-standing relationship with the Albert family, which is brought in by this sort of prior lawsuit that we brought to the court.
The Albert family appears to be huge, right?
Well,
or very extended family.
Well, I'm getting there. So
Okay.
the altercation that Lank was involved in was after he deputized himself to involve himself in a fight that Chris Albert had been in. Chris Albert is one of the Commonwealth's witnesses in this case. He is Brian Albert's brother. He was with them all that night on the 28th. His son, Colin Albert, as you know, is a third-party culprit. So this is not some tangential family member. This is—
Who would you intend to get, if I allow this, and we really need to see how things develop
This woman.
beforehand. So,
Let her
Mr. Yannetti,
finish.
I can tell you right now, I'm not going to allow you to open on this because I need to see how the evidence comes in.
It's not part of my opening.
Okay. Who would you intend? I see you have the Lopolito brothers on the witness list. I think that goes far further than I would allow. But who do you intend to get the testimony in through, and how?
Through Sergeant Lank himself. I think we
Okay.
need to be afforded the ability to cross-examine him. Once that's done, we may need the local
If he
law
denies
to—
it, and we'll
Exactly.
figure that out.
But I think the first step is allowing us to inquire as to his relationships and the connection that he has to the family and this incident that occurred.
So you can certainly inquire as to his relationship with the family. It's the incident. I need to see again, just reading of everything that I've read, Sergeant Lank doesn't have it, his testimony isn't as lengthy as other witnesses, right?
I don't think that that's necessarily true, Your Honor, as far as our
Mr. Lally said,
cross-examination.
okay, but for his,
Notice Lally is always afforded the possibility to make his arguments. Bev said, okay, who's going to argue this? Within a minute, she already cut her off. She set parameters for what she could speak about. And when she said, okay, I'll talk about that, 2 seconds later, she cut her off. She keeps talking over her. This is about the most biased judge I think I've ever seen.
She's terrible. Sorry. Can't even get
Yeah.
words out.
his direct is not as lengthy as other witnesses.
I think that's fair to say.
Yeah. So, all right. So go ahead. So through him, through Chris Albert.
Through him, potentially through Chris Albert as well, Your Honor.
Okay. All right. So, Ms. Gianetti's not going to open on this, and he said he wasn't planning on it anyway. So
No, Your Honor.
let's see how the evidence develops. It may be that we have a voir dire of Sergeant Lank and Chris Albert beforehand. Okay. So, I'm not going to take any action on this right now,
Okay.
but I'm not denying it as the Commonwealth's requesting me to do.
Thank you, Your
So
Honor.
we'll see where we go with this. Okay. All right. So now let's deal with the Trooper Proctor part.
So, Trooper Proctor, Your Honor, in regard to NEI investigation, which we have not received any material in regard to other than its existence. And I want to be clear on that because I think counsel might be a little confused by some material that we provided to them. So there were some interviews in regard to any sort of areas of potential bias with regard to Trooper Proctor and certain members of the Albert family. That was something that we did. So we had asked and a couple of captains from the state police who are completely divorced from the investigation and completely divorced from our office, conducting interviews with regard to Trooper Proctor and a few of the other civilian witnesses.
Okay.
in
How
relation to
recently? I mean, it's all recent. When was that?
that was, I think, all discovery related to that was provided to counsel the week prior to trial.
Okay.
But they were done sort of in the weeks leading up to that.
Is that part complete?
Yes.
Okay.
So as far as the IA investigation goes, just the mere fact that there is an IA investigation, the Commonwealth would submit is not an appropriate area for cross-examination, and particularly when it's an open investigation, there are no findings and falls squarely within McFarland and Graham. And I understand what the court's comments before about, them being primarily discovery cases, and I would agree with that. But they also go to discovery cases as far as so if something can't be ordered to be provided in the course of discovery, then it's, I would submit inferentially inadmissible. So what I'm suggesting with this motion, what I'm arguing in this motion is that whereas there is no findings of liability, there's no findings of any wrongdoing or anything of that ilk, just sort of putting out there that there's an open IA investigation without anything more because nothing else exists at this point.
Why wouldn't it go to his bias and his motive? If he's under investigation, why wouldn't he have the motive to testify favorably, or why doesn't it go to that? Maybe not the fact that it's IAD, but just there's an ongoing investigation that he's aware of, that he's involved. And I don't know if his job depends on it. I don't know that. Maybe there's not enough to know. But why isn't that motive and bias on his part? Do you think that's prohibited by Graham and McFarland?
I do, and just for that specific, because essentially what it allows a defendant to do is to pursue a line.
Because they want to go into it in the court and show that he is also dirty because he knows the family. He lied about it. Lally lied about it multiple times in court. That's why they don't want them to get into that. They are looking into him because he is a bad guy.
And a questioning that they have no idea what that line of questioning is or what it will eventually be. And it could eventually turn into nothing. And to allow that sort of imprimatur of the court to allow that sort of questioning into an area that is completely unsettled and completely there's no evidence to substantiate other than the fact that it exists without any sort of finding, without any sort of evidence to support it. I mean, we don't have any evidence as far as what that is or that it even pertains to this case. So with regard to
6 to 8.
all of that, I understand, that outside of McFarland and outside of Graham, that there are other avenues, as the court was alluding to, as far as motive, as far as bias, as far as things of that nature. But when it's just so scant as far as what that is versus sort of the connotation behind those questions, I just think it's unfair to the Commonwealth. It's unfair to the witness to be put in that position when there's really no information available.
All right. What do you say, Ms. Little?
Your Honor, I think that ADA Lally's representation that we don't know what this investigation is about is disingenuous, to say the least.
Why so? Why? Is there
Reason
something in
is-
the, hold on, is it something in the,
He spoke for 3 minutes and 4 seconds, I think I counted it to, without any interruptions. This lady spoke for 6 seconds.
information that you've received
Yes, Your Honor.
from
And
Mr. Lally?
yes, Your Honor.
All right. So can I get a copy of that?
Yes, Your Honor.
Okay.
So, as the court knows, first of all, Graham and McFarland deal with the Commonwealth's mandatory discovery obligations, right? Those courts also very specifically state that there's mechanisms outside of those mandatory discovery obligations for defendants to obtain information that's relevant and admissible at trial. That's why we filed a Rule 17 motion requesting these disciplinary records, and that's why that was granted.
It was granted because the Commonwealth did not object.
So regardless, we've obtained those records, and the cases that Mr. Lally continues to cite do not stand for the proposition that that's the only mechanism by which information can be produced at trial. Those are discovery cases. They are not admissibility cases. Pursuant to that request, we have received information discussing the IA investigation at which Trooper Proctor is being questioned specifically about this case. This is not an instance where we're questioning whether or not there's a basis for an IA investigation. It's clear this investigation was predicated on the materials that were produced to the Commonwealth by the federal authorities in this case.
And initiated by the Commonwealth. The IID investigation was initiated by the DA's office, correct?
Well, as far, and just to correct what I certainly didn't mean to impute that this case had absolutely no bearing or there was no
I
basis for
didn't
it.
think you did.
But
No, you didn't.
what I was saying with that is we don't know what the full extent of that is. But as far as what counsel is, what the court's question as far as the IAD, it was something that our office had spoken to. We felt we had a duty to disclose to State Police Legal Counsel, and then they refer it to the IA, and that's how that investigation began. As it pertains to what counsel was talking about, that has nothing.
I've said it since I heard her for the first time. She should really have some speech classes because her voice is horrible. She always sounds like this. And it sounds like she's on shaking ground or she is really intimidated. I think she's a brilliant lawyer, but she always sounds like she's afraid of the other side.
To do with IA. So the materials that the Commonwealth has provided.
Exactly. He absolutely did say it. He said that they misunderstood what's in the evidence we provided to them. He is a lying liar who lies, and it's constantly. Maybe my song tomorrow will be a Mr. Lally.
That was completely separate investigation initiated by the district attorney's office. In relation to that.
Okay.
The IA investigation came on the heels of this information being produced to the Commonwealth. This is not a situation in which we're really questioning what the basis of that investigation is. The Commonwealth has in its possession numerous materials that suggest there has been significant misconduct on the part of Trooper Proctor. That will come out at trial.
How?
However,
How?
Oh my
through
God.
cross-examination.
What if they don't call Trooper Proctor?
Then we will.
We will call
Then we
Trooper
will.
Proctor.
To impeach him?
Yes.
All right, so be prepared to argue that. I don't know.
People
He's on the
stop
witness
yelling.
list. He's the first person on the witness list. They're probably calling him. I'm just
He's the lead detective
hypothetically
in this
throwing it out
case.
there.
He's conducted every single step of this investigation.
With others, right?
Excuse me?
With others.
Sometimes, but he is the primary investigator in this case. And I
Why
think
are you
it's
trying to
very, very
protect
important
him
for
so
the
much,
court. And I
Judge?
think you noted
Yeah.
correctly that bias and motive are absolutely critical to Ms. Reed's right to defend herself at trial. We have to be able to explore those issues. And in order for Trooper Proctor to testify, he has a motivation to testify in a certain way to avoid liability in this pending IA investigation. So I think it's unfair to tie our hands behind our back and not be able to question him about this, because it directly drives his bias and motive in this case and gives him reason to testify in a certain way, knowing that he could face career consequences if he doesn't.
Do you intend
Yep.
to try and open on this, Ms. Gianetti? Because I need more information.
I'm not going to mention the IA investigation in my opening
Okay.
statement.
All right, so Mr. Lally, if you can get me that information that you mentioned that you
Sure.
had sent.
Why is she sounding like I don't care about anything?
She doesn't. It's been this whole time.
Yeah, she's constantly looking for a way to stop the defense. This is so bad, but they can't do anything because she's the arbiter of the rules.
To counsel. I'll take a look at that. It may well be the fact that
No, I
there's
don't think they feel
an
defeated. Her voice
investigation
is
without
always
what
touchy.
the nature of the investigation is, but that there's an important investigation. And if you can show me in advance that his job may depend on it, things of that nature, there may be cleaner ways to allow this testimony in. So, all right. So we need a little time. I need to read those materials.
Sure. And,
Okay.
and for the court's edification, I don't anticipate he's sort of towards the middle, I would say.
Okay. All right. Good. And the more fully the
That was an interesting little tidbit, Jamie. Did you notice that?
I didn't hear it. What do you say?
That they're going to call the lead investigator sort of doing towards the middle. Normally, you always have the lead investigator to summarize everything.
Yeah, wrap it
at
up.
the end.
Wrap up your case.
That's interesting. So
This
are
is going to be an
they
interesting trial.
are they believing that he will be so bad and they will hit him so hard on cross that they have to build their case up again after?
I think
It kind of
so.
sounds like it. We're gonna build up a case, and then we're gonna have him. That can go either way, and then we have to come back and make sure that they forget that he was there and it was so bad.
Yeah,
That's kind of how I hear it,
that's how I see it.
because I would say 9 out of 10 cases we have covered, the lead investigator always goes last to summarize everything.
Yep.
records developed and the easier to rule on some of these motions. I just want to give you all some idea so you know how to prepare for the next 2 weeks. So, all right. So not in your openings on either one of these, Ms. Gianetti, but you agree to that. So this is still under advisement. It may be certainly with Lank or Sergeant Lank of voir dire of Sergeant Lank and of voir dire of Chris Albert. We'll see how the evidence develops, and I'll read more about the information that the Commonwealth was provided. So 318, also it's 28 bolded from the Commonwealth. All right, so Commonwealth's motion eliminate to admit, this is, you know what, I don't have a number on this one, Jim. Commonwealth's motion eliminate to admit results of defendant's blood draw at Good Samaritan Hospital and resulting serum conversion and retrograde extrapolation.
Judge, that's paper 339.
All right, and the Commonwealth, I mean, the defendants is 289. It's the addressing the same the same issues. Yeah, I told the Commonwealth to put this in writing. So I guess it's defendant's motion. So I'll hear from the defense. Your motion 289.
Thank you, Your Honor. With regard to that, we've put most of our argument in the paper, so I don't want to rehash all of those. The issue is really the foundational issue, not the extrapolation. The extrapolation is sort of a garbage in, garbage out argument, like computers. We think that the underlying blood draw did not follow the proper protocols that it should have followed. Therefore, the veracity of that particular blood draw is at issue.
All right, can I just ask, the Commonwealth intends to have witnesses here to testify to that, right? How the
Yes.
blood was drawn,
Yes,
all of
the
that?
Commonwealth would have the doctor that ordered it, the blood draw, the nurse / nurse practitioner. I summons both as far as who took the blood, and then the director of the lab at the Good Samaritan Medical Center. What I
Okay.
hope to...
So let me get back to Mr. Jackson, and then I'll hear you on that. I just wanted that. I'm not sure we had all that information when you filed the motion, but does that change anything, Mr. Jackson?
It doesn't, because the individuals that did the blood draw, it wasn't done in an accredited manner. I'm not arguing with the fact that the blood draw was taken, that somebody with a phlebotomist actually took the blood, but it wasn't done with the protocols or the accreditation that's required under Massachusetts state law and the Massachusetts State Police Crime Lab. Their protocols were, I apologize, their protocols were breached internally. And given that breach, we believe that any extrapolation based or founded upon those faulty blood draws, those unaccredited blood draws, are suspect as well. So the sum and substance is that you can't trust the extrapolation if it wasn't an accredited.
You're kind of, I think you're behind, but yes, he wants to know what they're going to ask his witnesses. Welcome, Renee. Did they ask for the correct blood draw, or was it just a blood test? Well, it sounds like they asked for a correct blood draw, but protocols wasn't administered correctly.
And a foundationally solid blood draw to begin with.
So if all the witnesses are here for cross-examination, why doesn't that go to the weight of the evidence instead of the admissibility?
Because we think that the admissibility is based on the protocols that the Massachusetts State Police have put in place. If they didn't have accreditation protocols, it wouldn't mean anything. It probably would go to the weight, not the admissibility. I think the admissibility is predicated on their own rules. They don't get, in our view, they don't get to break their own rules and then say, oh, well, let's just let it go to the weight, not the admissibility. We believe that it's important enough that it shouldn't ever come in front of the jury in the first place, notwithstanding the fact that we could obviously cross-examine them on the lack of accreditation. We think that it rises to the next level of not being trustworthy, and therefore it's overly prejudicial.
Okay. Mr. Lally, doesn't this happen in hospitals across Massachusetts on a regular basis?
It does, and just to be clear, nobody's breaking anybody's own rules. This wasn't blood work that was taken by anybody at the lab or tested at the lab. It was taken at the hospital, tested at the hospital, and what the technician or the forensic scientist from the Office of Alcohol Testing is doing is essentially mathematical calculations based on that result. So I would submit it goes exactly to the weight of the evidence. It's certainly fertile ground for cross-examination or argument by counsel. But as far as it being admissible, it's certainly admissible. This is what happens in every case. Whether or not Good Samaritan Medical Center's lab is ANAB accredited or anything of that nature is irrelevant. It has nothing to do with the state police strictures because they're not the ones who actually conducted the testing of what was in the blood.
All right, do you want to respond?
I just wanted to refresh the court's recollection. I mentioned this at the last hearing, but just one element of the problem is in the result. The extrapolated result was 124% swing. In other words, we extrapolated based on the blood draw.
Yeah, I know what it means.
And that's just massive. I've never seen a swing that big. It's, you pull somebody over. Well, they
Sounds like a great area for cross-examination.
I think it will be.
Okay.
But if it's not admissible in the first place because it's inherently untrustworthy, then you could save me my breath.
Yeah.
That was a good way to say it.
I don't see how this doesn't come in.
I'll submit, I don't want to beat a dead horse. I just think that it's so unreliable that it shouldn't be put before the jury. And we run the risk of prejudicing the jury in a way that we can't sort of unring that bell. Yes, we can cross-examine, but I don't think that the underlying blood draw is foundationally solid enough.
Mr. Lally, were you planning on using this in your opening?
I don't have to.
All right, so why
So
don't
he
we
was
wait
planning
and
on it.
if need be, we'll have the experts. Let's wait until it gets closer to these experts or the folks from the hospital testifying. If we need to have a short voir dire, you need to remind me to do that, Mr. Jackson. Okay.
Thank you for that, Your Honor. Appreciate it.
All right. Okay, so
But
the
you're
last
just in time
area
for the rest
I
of it.
have is sort of logistics and sequestration. So let me, so the Commonwealth filed a motion initially. You know what, we'll hold off on the logistics regarding the audiovisual assistant. So there was a motion in limine for sequestration that I allowed regarding the family. So the victim's brother, Paul O'Keefe, the sister-in-law, Erin O'Keefe, the niece and nephew can attend the trial after their testimony. So that motion 293 is allowed. I understand that perhaps, well, I was going to also allow Mr. O'Keefe's father, who appears for some reason on the defendant's witness list. He is exempt also by me from the sequestration order. All right, so that's John O'Keefe Sr. So I just added that in. So Mr. Clerk, 293 is allowed with the addition of Mr. O'Keefe
Thank you.
Sr. So the Commonwealth has filed a two-part motion, a motion for offer of proof regarding calling the elected sitting district attorney of Norfolk County and sequestration order if he is permitted to be called. This also includes Stephen Nelson, who is the victim witness person. So why don't I hear you, Mr. Lally or Ms. McLaughlin? I'll hear you on this motion.
Yes, Your Honor. So the reason for this motion is, as the court noted, they appear on the defendant's witness list. Neither of them, I believe, has received a summons in regard to it. So there's no motion to quash because there's no summons to quash. But with respect to each, as the case law is abundantly clear, in order for these witnesses from a prosecution team to be subject to being called as witnesses by the defense, the Commonwealth is just seeking some sort of proffer whatsoever as to what areas they can testify and only they can testify to. So if it's information that the defendant can elicit either through direct testimony or cross-examination from, and I would submit whatever, I would believe that whatever testimony they seek from either of these witnesses, they could get ample testimony from a multitude of other witnesses. Specifically, the only point that was raised as sidebar during impanelment was with reference to the district attorney testifying as to whatever issues, purported issues of conflict or removal of Canton Police Department from the investigation. Certainly those are questions, I think, far more appropriate for members of both the Canton Police Department, members of the State Police CPAC Detective Unit. The head of that unit, Lieutenant Tully, is one of the Commonwealth's witnesses who will be testifying, and I think he's in a far better position to testify to that than Mr. Morrissey. But regardless of that, what the case law is very clear about is that, number one, the victim witness advocate is a part of the prosecution team, and in these sort of areas stands in sort of the same stead as a prosecutor himself. Secondly, with respect to whatever areas of examination are expected or anticipated from these two witnesses, there has to be some sort of proffer of what that anticipated testimony would be that they can't get from some other witness. Certainly, Mr. Nelson has been the victim witness advocate working on this case.
So why don't you explain to me, I did look at the victim's Bill of Rights, but why don't you explain to me exactly what a victim witness advocate does, the nature of the relationship with the victim's family? I know there was a lot of discussion about this in grand jury minutes that I read about scheduling appointments, meeting with people, things of that nature.
So, I mean, what to say assist, I think is doing it somewhat of a disservice as far as the prosecution. It's someone who works directly with the prosecutor on virtually every step of the case, as far as investigation, as far as pending motions, as far as trial.
Has Mr. Nelson been the advocate throughout the pendency of this case?
Yes, Your Honor. So for over 2 years, has been the point of contact with the family, has been with the family at each of the court dates.
Yes, have through most of whatever we've heard is yes, but all of a sudden there was rumors that his father wanted to be seated behind her in the defense side, whatever that means.
Is assistant and very helpful as far as coordinating things with the family, coordinating meetings, scheduling meetings with witnesses in preparation of grand jury, in preparation of trial, has communicated thoroughly with regard to issues of scheduling and all of those types of things.
Does he take calls like late at night from witnesses? Does he have a personal relationship with witnesses governed by a professional relationship? Is he somebody that they are able to call? There's been a lot of allegations of harassment of witnesses.
Correct.
Are those folks able to call him when something like that happens?
That is the person that they would call.
Okay.
Yes. So I think the bulk of the communications and conversations with witnesses who are not members of Mr. O'Keefe's family over the course of the last couple of years have been in relation to that issue specifically, as far as harassment, threats, intimidation, things of that nature, that he's dealt with admirably in relation to those witnesses.
Okay. All right. Who's arguing this for the defense?
I will, Your Honor, and I think it makes sense to separate out DA Morrissey and victim witness advocate Steve Nelson in
Okay.
this argument.
Let's start with Mr. Nelson.
Sure. Your Honor, the defense acknowledges that there are often times where, let's say, a victim witness advocate sits in on an interview with a witness or an alleged victim, but there are other witnesses in the room to whom or who could testify about the content of that, and that doesn't necessarily make it proper to call a victim witness advocate during a trial. I acknowledge that. I also acknowledge that the victim witness advocate has a job to do, and it puts them as sort of an intermediary between the prosecutors and the police and alleged victims.
So when you were a prosecutor, you worked very closely with victim witness advocates.
I did.
Okay.
Yes, and it's my experience being on the other side that informs my knowledge of that. But this is a different case with regard to one specific issue. And that is that we learned as a result of the federal materials that victim witness advocate Steve Nelson had conversations with Brian Higgins and we believe Brian Albert, but Brian Higgins talked about him specifically. Mr. Higgins was asked, where is his cell phone? Why does he not have it? Are you aware of the preservation order that was issued by Judge Krupp in the Karen Reed case? And the answer came back that he was given permission to destroy or dispose of his cell phone from victim witness advocate Steve Nelson.
Did he say destroy? I'm trying to remember the testimony. I don't think he said destroy.
I used the disjunctive rather than the conjunctive because from memory, I can't remember the precise language, but it was conveyed to, I'm told that the precise language was to get rid of. Which, would be consistent with what I had
told
said.
He could get rid of, not
Correct.
Told he must get rid of.
Correct. In other words,
Oh my God.
Steve Nelson is overruling a colleague of yours, your predecessor on this case, who issued a preservation order which was never lifted. And yet he stepped into the case, gave authorization that he did not have to give for the disposal of a phone, which is relevant.
Okay, is that the sole issue you want to?
Yes,
The sole issue?
yes, that's with regard to Mr. Nelson. It's different with regard to Mr.
All right,
Morrison.
what's the Commonwealth's response to that?
I don't believe any of that is accurate. So what counsel is referring to is there was a motion to preserve cell phones. The Commonwealth notified each of the witnesses that were subject to the motions and the orders, sent copies of the motions and the orders, as well as a letter explaining that. There were conversations in regard to that. There was then a subsequent Rule 17 motion filed specifically for the physical phones. There were conversations with those specific witnesses, just advising them that the Rule 17 motion had been filed. They had to, hold on to their phones, things of that nature, explaining what the process was. The hearing was conducted, the Rule 17 motion was denied, and then those witnesses were subsequently informed that the motion had been denied. I believe even from Mr. Higgins' testimony in the federal grand jury the counsel is referring to, he was specifically asked whether or not he had been ever advised by Mr. Nelson, myself, or anyone from our office that he could or should get rid of his phone, and he said no. So I don't know what further needs to be explored on that particular point, as the question was, all of these issues were explored in that particular area, and just because counsel, I think, may not like the answer or doesn't believe that the answer is truthful or whatever, that does not then permit bringing in this witness to testify to what they know is not true.
All right, so Ms. Giannetti?
We believe that that's a misstatement of what was testified to. I think it probably makes sense for this court to look at his very testimony so that you can make a decision on this, Your Honor.
So here's what I'm going to do. Let's wait and see. Let's wait and see how Mr. Higgins testifies. Okay? I am not going to order sequestration of Mr. Nelson, and let's see how the testimony is. And if you need to call him, you let me know, and we'll have another hearing on it.
Okay, we'll do it. And just to answer an anticipated question from the court, I do not open on this issue.
You cannot open on that issue, Ms. Giannetti. Do you still need the 45 minutes?
That takes away nothing from my open.
This is, if
All right,
that's,
so Jim, I'll start writing. I'll write something on this.
if this is in, I believe Yannetti before I believe Lally. If he testified before a grand jury that he was told that he could get rid of his phone, and there was a preservation order, Jeepers Christ, how is this going to trial?
I know.
What?
Your Honor, with regard to the sequestration, I think it would be appropriate for the court to order that Mr. Nelson and Mr. Higgins not discuss this issue from here forward.
Are you willing to have that happen, Mr. Lally?
That's fine, Your
Yeah,
Honor.
I'd order it, but he's willing to do it.
Thank
so.
you.
All right, so
Yeah, you ordered a lot of things he didn't do.
Yeah. Exactly.
I just need a minute to write this up.
Sure.
This is it's even worse than I thought it was.
Mm-hmm.
I believe that they wouldn't bring it up if they couldn't back it up in the testimony from the grand jury. And this is, all of it is just because Mr. Yannetti and Mr. Jackson can't read the testimony, because Alan Jackson clearly, Lally clearly reads better than they do. This is, why do I think you don't want him to testify? Because if it's true that Higgins said that he gave him the permission to destroy his phone against a court order, that's a big problem. That's illegal. they should have the same. Well, I don't know, because there's a lot of child murderers and rapists out there. I really want to be put in prison, so I don't know. Is this John's brother, or who is that?
All right. So regarding DA Morrissey.
Yes, thank you, Your Honor. So, Your Honor, the integrity of the investigation that was done in this case is certainly a live and important issue
I think
that
it's
is
his
part
brother and his
of
mom.
the defense in this case. I think the court would agree that we're entitled to question the integrity of the investigation, to attack it where we can. And it goes without saying that as the district attorney in Norfolk County, Michael Morrissey is in charge of that investigation. Now, in the usual case, that doesn't necessarily make a district attorney a witness. That would be unusual. There probably have been very few requests to have a district attorney testify in that regard. However, this case is different for two reasons. One is the conflict of interest regarding the Canton Police Department, which Mr. Morrissey was involved in. The second is the manner in which he injected himself into this case personally and made representations that we should be allowed to challenge.
Do you want to play that video?
We haven't made that decision yet. It may be that we elect to play portions of the video. It may be that we just elect to question DA Morrissey.
I have to think of other ways, right? That's part of the analysis that I have to follow in the law. So that's why I'm asking.
Of course. And I think before we get to that issue, Your Honor, the conflict issue is what puts him on the stand first. And we learned from the federal materials that former Chief Kenneth Berkowitz notified DA Morrissey at a very, very early juncture at 8:30 a.m. A phone call from Chief Berkowitz to DA Morrissey notified him that Kevin Albert is on their force. He's the brother of the homeowner whose lawn contained the lifeless body of John O'Keefe, and that DA Morrissey was involved in that decision. He received the information from former Chief Berkowitz and concurred that the Canton police were conflicted out. And then the problem is that the Canton police they had their hands in this investigation, including that day after 8:30 a.m. and going forward. And there were, updates that were provided to Kevin Albert by a trooper under DA Morrissey's control, that, there were violations of that sort of conflict of interest taking Canton out of the case that DA Morrissey became aware of and that DA Morrissey did nothing about. And so in terms of, us being able to, attack, question the integrity of the investigation.
Why can't you do it through other witnesses?
We can, but the buck stops with District Attorney Michael Morrissey. He was the one that was involved at a very early juncture on this precise issue of the conflict, and he became aware that that conflict was violated time and time and time again, and he did nothing. And I believe that that's ripe for cross-examination. And, with regard to his statement to the press, this may even be more compelling, not because of the bias necessarily that he showed. That's not the strongest part. I think it is strong, but it's not the strongest part of his statement. His statement makes factual assertions, some of which we heard for the first time. In that videotape statement, he announced to everyone, including potential jurors, that Trooper Proctor never reported to the scene on January 29th. That's in direct conflict to police reports that we received from the troopers saying that they reported to the scene. And we would argue, trying to use semantics to get out of that, and now saying that for the first time in my career, I've heard that the crime scene is actually the police station that's across town. doesn't make any sense. It doesn't pass the straight face test, but those are his own words. And he made himself a witness by uttering those words. And he also talked about his view of what witnesses did or didn't do and whether they're suspects or not suspects. Again, he injected himself into this case. He made himself a witness. And there's really nobody else we can question about his knowledge that he had when he made those statements and why he made those statements. And also the fact that, you know, he was involved in this conflict decision from the beginning. So that's our offer of proof.
Mr. Lally?
I mean, as far as his statements, his opinions are completely irrelevant. And I think what counsel is referring to as...
No, because she went on television and said she's clearly guilty. All of our witnesses are hunky-dory, and Proctor never was on the crime scene. So that's why isn't that tampering with the jury pool? Freaking idiot.
Proper for cross-examination, they might be, but this would be a witness that they're calling themselves. So for direct examination of your own witness, I think it's improper, number one. Number two, there is ample other avenues to explore this through other witnesses, which counsel can certainly do, you know, as related to whatever.
As the law tells me I have to consider.
Correct. And so, you know, as it pertains to
She never argues. She's always just, yeah, you're right, brother.
whatever extent the court allows as far as the Bowden defense is concerned, then I think it's fertile ground for cross-examination of other witnesses in respect to that. But as to whatever statements were made or not made by something that someone doesn't have recipient knowledge of, because I don't think anybody's saying that Mr. Morrissey was at 34 Fairview Road. So with all of those things in consideration, I don't think that it's even close to a valid proffer as to why the district attorney or Mr. Nelson need to testify on their own as to any of those things. The last thing I would just note is with respect to Mr. Nelson, the alleged mischaracterization that I made in regard to Mr. Higgins' testimony is actually contained on page 140 of his testimony. 140? 140.
Yeah. Could you read it? Do you have it there? If you don't have it there.
It's more so I don't know that I'm
okay.
ready to.
Okay.
Your Honor, if I could just add one thing that I should have mentioned, which is on this issue of whether there's another witness that could testify.
Yes, because you did say, yes, we can get it in through other witnesses.
Yes, except the one thing we can't get in through other witnesses, potentially, is the phone call from Chief Berkowitz to DA Morrissey, where, as I'm understanding it, there were only two people on that call, and the Commonwealth is seeking to take Chief Berkowitz off the witness stand as well.
Are you? I didn't see anything like that.
No, I'm not seeking to keep him off the witness stand. What I informed counsel is as to his current medical condition, and informed counsel that's why I didn't summons him. But I'm not seeking
I knew nothing about this.
prohibit him from testifying.
My understanding was that the prosecution didn't believe that he would be able to testify.
This is the first time hearing any of that. All right. So it is.
You don't know what's going on half the time.
And again, she didn't say, what? He isn't able to testify? Why didn't I hear about this? She said, oh, this is the first time I heard about that. Okay. So Morrissey should be a shoo-in if the other guy who was on the phone call can't testify. That's nice.
A stretch. It is an uphill battle for you, Mr. Yannetti. I will allow you to revisit the ADA Morrissey at the close of the Commonwealth's case. Right now, that your offer of proof is not enough. I'll give you the opportunity to do it again based on the testimony that comes in, and I am not excusing him, or he is not subject to the sequestration order.
Understood, Your Honor. Thank you.
Okay. All right. So, Jim, I'll write something short on that. I've written the part about Mr. Nelson that I'll give you afterwards.
Great, thank you.
All right. So, when we had our motion in limine hearing, I think we went much of the day that Friday. I don't remember if it was last Friday or the Friday before. I ended that with saying twice, Is there anything else we need to discuss regarding housekeeping or logistics? And I was told no by both parties. And then I get a motion the following April 19th, the end of last week, about wanting to use not just having an a technology audio visual assistant at council table, but to use, it's much more extensive than what I expected. The Commonwealth filed their motion and it was allowed previously because it happens in every single case in these.
Yeah, if they couldn't put new things in, so the DNA evidence that Lally put in last Monday should just be thrown out. Oh, of course not.
Courtrooms, and the Commonwealth shares their equipment. Please tell me exactly what it is you want to do. And I'm mindful also of the fact that during impanelment, while we were actively on trial in this case, in a critical part of the case, your audiovisual person, who I had never seen, was sitting where you are, Mr. Yannetti, talking to your client. So it sounds like he's taking liberties in this courtroom, and I need to know exactly what you need him for and what it is you intend to do. Keeping in mind also that we're going to be now in a much smaller courtroom. So tell me, are there any agreements of counsel? Is there any, I know nothing about this, and I asked for information previously so I could have thought about it and, seen a demonstration or heard something. What is it you're asking me to allow?
Thank you, Your Honor. It's very modest. We did mention that we were going to ask for this.
But you didn't do it in writing, and you didn't give me specifics.
Your Honor, we asked you, and you then said, put it in writing. Then we put it in writing.
But the first time it was brought up was after I had asked about logistics. Go ahead. Tell me exactly what it is you want to do.
Okay. So it's a very modest request. Under ordinary circumstances, we've utilized his services before. He would sit at counsel table, and he would run sort of the AV to make it seamless and smooth for everybody, for the jurors, for the court reporter, for opposing counsel. He can put monitors at the request of the court, put monitors on the bench, a monitor in front of the court reporter, a monitor in front of the Commonwealth, and a monitor here, all small, relatively inobtrusive monitors. He also can run the system of AV, in other words, putting up evidence. I'm looking at evidence binders that Mr. Lally and I are going to be visiting about through the day today and tomorrow. There's hundreds and hundreds and hundreds of photographs in here, multimedia, that's going to need to be played and shown throughout the course of the trial. Instead of walking back and forth and doing it sort of.
That's why he earns the very big bucks.
No, and that's what we do every day in this courtroom.
Right, and that's what he does every day in courtrooms as well. I mean, all we're asking for is an accommodation exactly like the Commonwealth has. It's just easier for.
No, this is just an IT tech who makes sure. Have you seen how many times these idiot lawyers goes and say, "How do you connect an HDMI cable?"
For us, if I'm up on a cross-examination or Mr. Yannetti is up on a cross-examination, and we say, okay, if let's say we've got internal bait stamps that show photograph number 231, he'll know what photograph number 231 is. He'll have an outline that tracks our cross-examination or direct examination.
So it will be only things that are in evidence or will be coming into evidence. You're not going to do that with disputed?
Absolutely not. We would never do that. If there's anything that's disputed or even remotely controversial, my habit and practice is to ask to approach the bench. We all walk up. I say, this is what I'm proposing to show the jury, and the court rules on it. But no, all it is just a sort of a facile accommodation of seamlessly showing multimedia or playing an audio or playing a video for the jurors.
All right. What's the Commonwealth's position on this?
Your Honor, given that representation, I mean, that's precisely what we do in every case in which we have either Ms. Gilman or Ms. Crawford or whoever assisting with the trial. If that's what it's limited to, I don't know about the additional monitors or things of that nature, whether or not, especially if we're going to be in courtroom 25, whether that's really necessary. But certainly whatever logistically we have as far as equipment or screens or whatever is obviously
Sounds like she's dying.
fully, we would fully make accessible to defense counsel as well, as we do in every case.
All right. So, in Suffolk County, there are monitors. The audiovisual equipment is fantastic. There are the jury seats. They're for everybody to see. There's even a way if something is an objected to motion, it can just be seen on the lawyer's screen and the judges. So the bottom line is, if we had known about this 2 months ago, we would have been able to really put the time into seeing exactly how this works. Ms. Giannetti, I'd like to finish first, and I'll give you the opportunity to speak to Mr. Jackson, to really see how this works, see how we set it up. I can't devote that time to it right now. No monitors, I don't want a monitor. I'm not allowing, or Madam Court Reporter is fine. We're in that very small courtroom now at your request. So we don't need monitors on the tables. I don't have the time to physically go see how this all looks. Ms. Gilman's here. Perhaps she can speak with your audio-visual person, and then you can all make a presentation to me. But again, this, months ago would have been much better.
Well, I understand the court's concern. This is extremely modest, and it's not going to take a whole lot of presentation. If the court doesn't want to monitor, the court says, I don't want to monitor.
I don't know if I want monitors on those tables so close to the jury.
That's fine. Then the court can say, I don't want monitors that close to the jury. Then what I would do is just use paper copies. When I'm up on direct or cross-examination, I don't want to I can't prepare with the Commonwealth's.
No, I understand that.
I'm not
I
sure
don't think he'll fit at counsel table.
I can't speak to that. I think he would. I think we could accommodate him. Or if he doesn't fit right at counsel table, we've also set up, he was on a relatively large case that we had in a small courtroom back in California, and he set up just behind counsel table, and he's got his own laptop and nobody else can see it. And he's got a type of screen that you can't see it from angles. So jurors are not going to be seeing anything, but I need to be able to, and Ms. Little and Mr. Giannetti need to be able to prepare with him. And I think the court.
No, I understand that. I don't have a problem with that. It's the 4 monitors on the tables, one on the bench, one for the court. We're in a small room.
We won't do that.
And I'm concerned about the amplifying sound. I mean, is it like movie theater sound? I mean, it's, again, a tiny room at your request.
He uses very modest speakers that are appropriate for the space. So for instance, in this space, it would be probably a couple of speakers that are larger so that the jurors can hear, or the court can hear. In a small space, he'll just pare it down and use small speakers. And there's a switch. So for instance, he will work with Commonwealth's AV.
That the problem is that Bev doesn't understand it. She thinks, is it movie theater sound? No, it's just any lawyer in here, or anyone who's ever been in the courtroom, there's no worse audio than in a courtroom. So they just want to make sure that everything works. And he needs the presentations in the way he needs. He can't stand there if the state is supposed to run his audio visuals and say, can I have 233? I don't, and it breaks up his rhythm. She's just an idiot.
Expert. And there's a switch on both tables. When it's my turn, switch. And now.
All right. So is that switch, are you putting wires? I mean, these are all the things that I shouldn't be dealing with. I mean, we just got Wi-Fi in this building a week ago. I mean, it's not a building that,
I understand.
we can just last minute. It's a beautiful old historic building. We want to keep it that way. So.
And we will not mess anything up. As a matter of fact, I was told that by the Commonwealth that she uses switches consistently. That's not new technology. It's very simple. It just allows both of us to be able to prepare with the audio-visual portion of the case more seamlessly. That's all. We just want to make it more seamless and more professional for the court and for the jurors.
So it would be during your case in chief?
It would be during my cross-examination of every one of the witnesses. I mean, the bulk of the case is going to be the Commonwealth's case in chief.
All right, with exhibits that are already into evidence, you're not trying to enter exhibits
He
during
already said that, you
cross-examination?
idiot.
I mean, unless it's an impeachment that I didn't see coming. But even in that case, my habit and practice, my custom and practice would be to approach, if it's a matter in controversy, or tell the Commonwealth in advance, I'm about to show this photograph. Do you have any issue with it? No, I don't. And then we'll show it. But I would never, the point of it is not to ambush anybody. It's just to make what is going to be shown and what's allowed to be shown seamless and more professional looking.
Does the Commonwealth and Ms. Gilman have an opportunity to spend a little time today to take a look at it and see? I mean, everybody's preparing for trial, obviously. Again, this is,
Well, you have 3 days.
I don't have the time to do it, and I understand if you don't, but.
I think Ms. Gilman can spend some time. She actually had made arrangements to meet Mr. Bates here last Friday, and he didn't appear when we were told he was going to be here. So, but I'm happy to have Ms. Gilman.
Of all these
Ms. Gilman, are you
remarks,
willing to spend some time today? Thank you.
By the way, just on Mr. Bates's defense, yes, he was supposed to come last Friday. He was told he couldn't come because he hadn't gotten permission from this court yet.
Okay.
We did not.
Well, that makes sense, frankly.
I just didn't want there to be a sort of a.
Lally knew that before he uttered those words he just did. This freaking little garden gnome looking idiot is using every little possibility he has to put in bad remarks about everyone because he
Hanging Chad where that's concerned. He didn't leave.
Well, especially where he didn't start out well, right? Being at council table during impanelment.
I understand that. And he's been told that that was inappropriate and obviously would never happen again.
All right. So some sort of ground rules. Only one counsel, whoever's doing the cross-examination of the witness, objects. Just one, not all of you. It's not a tag team. So one person objects. If you want to approach the witness, you must ask permission. At sidebar, there will only be one person talking again, and it'll follow with whoever does the examination. Many times I allow counsel to discuss things, and many times I call directly on maybe appellate counsel or counsel who's been the big law person. So you can ask me for permission for that, and no basis for your objection. You just simply object. That's it. And if we need to see you at sidebar, we'll see you at sidebar. But I don't want a whole litany of reasons why the testimony you think is inadmissible. So those are pretty standard rules. I'd like to see counsel at sidebar regarding a jury issue.
Just a second.
and we're caught up, I think. Yeah.
Finally.
Jamie, that's amazing.
It is.
Yeah, sadly, this will be the last day they will be in this courtroom. The case will take place in a smaller courtroom because the jury can't see the witnesses from the jury box, which is stupid.
That was ridiculous. I've seen the pictures.
As we expected, everything the state wanted, the state got.
Yep.
Well, I don't know if it's all for today. They had a jury question. Peter, yeah, the basis of the objection is because she doesn't. If they're saying objection, hearsay, Your Honor, because he was told this by some other person. That's the part she doesn't want. She probably want them to say objection, and she will say basis, and they will say hearsay, and she will either say approach or probably 95% of the defense objections say overruled. I think they are still at sidebar.
Mhm.
They better be ready soon because Jamie has a meeting at 1.
Yeah.
It's yeah, but again, the more I see Bev in the seat, I believe they have a very tough case ahead of them. She can only pray to God that the jury is a good jury.
Yeah.
Because this is real. It's very biased and very prejudicial, in my opinion.
To try and keep so much out of these cops that were clearly.
I'm on LNC too, Beth.
Yeah.
Yeah, probably Lally will slip up and make speaking objections all the time. Yeah, that's the only thing you can pray for. Is there any rumors out there if it's over?
Right.
Karen Reed had all her motives to see her ex-boyfriend dead, though. What motives? That they had an argument a month before. I can't see the motive in that because on the night there was no indication they were fighting. Nope.
Mm-hmm.
I really don't care about Weinstein. Never followed that case. I hope if what he did is true, that he will end up in the sun. But no, I've been sitting here all day, so I don't know what's going on. Yeah. Jamie, how many times have you told one of your previous boyfriends that you hated him because of something stupid?
I can't even count.
Great success. If you never heard that, you haven't been in a relationship. You
I
need to
say
go
it to people
mow.
I like too, so
Yeah.
it could be taken out of context.
So and very aggressively. Yeah. When all arguments happened, I told Sean and emailed him, and he never covered it either. Lol. Yep. I did. Was it televised? The Weinstein trial wasn't one of those that we kind of didn't talk about because there was too many rich friends involved in it.
Yeah, I didn't pay any attention to that one.
I don't know if this is over. The judge has not made a formal announcement, but it sounds as if she has decided to move the trial to another courtroom. The defense has said it was better sidelines for juries to see. Well, yeah, we kind of figured that one out as he said it. I can't see. But let's do what we talked about before, because those people that isn't experts in crime reconstruction, because they don't have the papers. These are those people. They work for ACA. And what are one of their top things? Forensic engineering and expert witness consulting.
I mean, look at.
ACA's engineering teams are comprised of a wide range of technical disciplines such as biomechanics, accident reconstruction, crashworthiness, failure analysis, human factors, premise, liability, and fire and explosion. Our experts use cutting-edge technology and software during their investigation and research. This enabled them to identify and analyze the fact of a case or claim in an expedited and cost-effective manner. All of this combined allows our experts to prepare comprehensive reports of their final findings.
But they're not qualified.
No, because they are only biomechanical engineers.
Mhm.
We can help with all phases of your project or case, from initial investigation and evidence preservation to design, testing, expert reports, depositions, exhibit preparation, and trial testimony. Our experts use the latest technology in conjunction with scientific principles to evaluate injury causation, equipment failure modes, and effects, accident, incident reconstructions, the impact of human factors, and property and premise liability. We have the ability to test and validate our findings in our on-site testing facility and then translate our findings into clear, credible, and useful data. Our core capabilities include forensic engineering and expert witness consulting. Our engineers use a variety we read that already. So this is a company that, it looks like the stream ended.
Okay.
This is a company specializing in doing exactly what they said they were specializing in. And remember, it's not the defense who ordered that report. It's the feds. And he claimed the opposite, that he did that at I believe the fourth hearing, that it was the defense experts, the defense team's experts. And now today, I don't know where anything about them. Well, it was kind of in the Fed report that you got in January, I believe we got the Fed report.
Mm-hmm.
So, yeah. But
A bunch of BS today from Lally.
yeah, but he's lying so much and constant. And I really hope that they have that piece of paper saying, because we know how he lied about her testimony at the police station.
Mm-hmm.
Really hope it. Yeah.
They want to play it still, like, what?
Yeah.
I don't know. That is what it is. They got to put in all they can put in. And then that interview she did.
Yeah, again, and experts just have to do a voir dire. Well, they're biomechanical engineers. They're not crash site reconstructionists. How do you know? What do you take a degree in crash site instruction? Must you have a doctorate, or will you just do a normal voir dire and say, "Yeah, I taken extensive courses," because their Celebrite guy, if he works for the police department, did 2 weeks at the Feds Academy. Probably drunk every night and trying to hit on that secretary who was also there.
Yeah, it was interesting.
Well, I can't see it on under the hashtag can read, but yeah, it looks like they're not coming back.
Yeah.
Once Lally plays the part of Karen's statement at the police station, I feel like that opens the door to the defense talking about why she said that. Yeah. And again, he totally misrepresented what it was. And you're going to see it. No, you're not going to see it. You're going to hear it. And what you will hear is, are you kidding me? Are you in on this?
Mm-hmm.
You know, they beat him up and no, you know, what was it? And John exploded. It's clearly
Pulverized. That's what she said.
Yeah, pulverized. Yeah, it's clearly sarcastic. Well, she isn't because no one is as cute as Jamie. I don't know, Wicked. I can just tell you that they had a website called Arca. Nothing really other than they're moving to a smaller courtroom, and Bev is. I'm more worried that Karen Reed will be found guilty now after watching today's hearing. She have absolutely no cool when the defense asks any questions, and she lets Lally get away with lie after lie as always.
Yeah.
All the motions that he wanted, he got. All the motions they wanted, she would take under consideration. Yeah, opens the door wide open for the third party. Yeah. So, but you clipped it and ran a vocal in isolation to hear her better. Yeah, but no matter what you did to it, you never heard her say, "I saw them bust my tail light with his head."
Yeah, he said she saw Colin and Brian Albert bust his head into the tail light or whatever she said.
Break my
He said she said-
break my tail light with his head.
Yeah.
I think Jim is the court reporter. I don't, or her clerk. I don't think it's Lally.
Yeah, I think it's the clerk guy.
So, but yeah, a whole bunch of. We shouldn't have watched it today, Jamie. I feel more worried about her now. I have to say.
I know. I'm like it makes me a little more worried, to be honest.
Yeah. I don't know. I'm so afraid how she's gonna rule doing this because she is so highly biased. Yeah, I wish she had a judge like Koberger's. He actually seemed pretty neutral. Chad Staples' judge is pretty good too. Yeah, and Judge Borowski could be great in this one because the state didn't get any legs up on him.
They also weren't being super shady like this guy is.
Yeah. Yeah, I know Turtle Boy has sources who told him stuff. Again, can we use it for anything? No, the case starts Monday. So hope she got a really good jury because they are the only one who can go against a dirty judge. Yeah, Chelsea B is correct. She has a very good legal team, but the problem is if she is she gonna do what she did today? Constantly interrupt them. The state is gonna object. She's gonna rule in favor of the state every time they object, so the defense can't make a proper trial. That's another thing I'm worried about. Very worried about. Let's just say that.
We'll see. I think I mean,
KKB. I'm pretty sure that all of them is correct. The problem is court starts Monday. It doesn't change anything. What we have to rely on right now is court starts Monday. Bev will be the presiding judge in that case. All the magic words, all the magic FBI will save anyone. No. Monday at, I don't know, 9 or 10 o'clock, court starts. From there on out, just have to pray for a great jury. Can something happen? Of course it can. But always believe everything you hear out there, no matter how positive it sounds and how many says, oh, I know this won't never go to court. I've seen a lot of those over the year I've covered this case. This will never go to court. We start Monday. She has an amazing defense team. The lady lawyer really has a problem with her voice. Other than that, they are great. They have to do the best job possible. Don't believe in abracadabra. Always believe that you are behind on points and go fight for your life. And what's on someone's list somewhere, I don't care. I don't care if it's Turtle Boys or if it's Grants, because court starts Monday, and everything that counts is what comes into the courtroom. And if all of what's on Turtle Boys list, that Higgins flipped and all of that, if that's true, it's going to be a very interesting case. But the defense, or the state, still have Higgins on their witness list, so I'm not sure he flipped that hard, because then they wouldn't have called him. So that's a big problem for me. And I hate to be Debbie Downer. It would be way smarter for me to sit here and say, "Oh, yeah, she's gonna be free." It's never gonna go to court, because that grift is way better. People like a positive person, but just don't get your hopes up. She is behind on point one. Every court case where someone is accused, a lot of jurors have a bias saying she wouldn't be accused if she hadn't done something wrong. That's behind on points. 2, this judge. Oh my effing God. 3, this prosecutor, he will lie worse than we saw in the Zachariah Anderson case. So Indian evening prayers until Monday. Mention her and pray for a very strong jury, because all ifs and buts, they're fine. But it's what you can prove in court and what you can get the jury to believe in court. Feds won't be there Monday with their guns out, as I saw some people dreaming about on Twitter. They won't magically overturn everything. Jury will be impaneled, a case start Monday, and Bev will ruin as much as she can for the defense. I'm sad that I'm a bearer of bad news, but rather that than you sit and think, I thought it was going so well. So I don't care if it's Grant, if it's Turtle Boy, if it's whoever it is who says they've heard something. It's fine. They probably did. I don't know about it. But in reality, we start Monday morning clocking at 9 or 10 o'clock.
Mm-hmm. All right.
I'm not trying. I know that. But I'm just saying it so, because a lot of people get their hopes up every time Sean in Florida says, well, I know this and that, or the other side gets their hope up when Grant finds out that Karen's dad is a FBI agent, so it's an illegal investigation for the FBI. Any of all of these theories, we are in the home stretch now. The opening pitch is Monday morning. And I can't see anything happening before Monday morning that will do anything. And then we just have to hope that Bev can't ruin this case. This is my biggest problem with this case, is Bev. She can hamstring the defense all the time.
All right. I will talk to you later. Bye, guys.
Hey, bye you. Bye.
Bye.
Yeah, stock up on heartburn medication. I'd probably lie to get on the jury so I could vote not guilty. Have to fight corruption with their own methods. Yeah, but again, do you want to go to prison? Because that's illegal. What you should do is remember, I don't know, how many years is it Morrissey has been the DA unimposed? Fish rot from the head. Vote against all of this. I don't care which side you're on. Yeah, I like sarcasm. It's my second language. English is my third. At least 10 years or 10 times. I don't. Remember this when the next time you sit at home and it's raining on a day where you can vote on these matters. Maybe take those 10 minutes and go down, and I don't care if you're a Republican or a Democrat or an independent. Your vote matters. You can change the system, but you can't do it by watching me or Turtle Boy or The Glare or LTL or Tom. I can recommend all of them. All of them are great streamers, Brandy Churchwell, Melanie Little, all of them, great people covering this case. But if you live in that area, you have a direct impact. And if you don't live in that area, think about it on the next rainy election day. This could be you. Next time you get that jury summons and you think, F it, I'll do anything to get off that jury. This could be your brother. The next time you think, well, I'll back the blue no matter who. It could be your sister being investigated by Proctor. I know that's not a sobering thought to have. In Denmark, we have a system where everything is appointed in the legal world. You have a system where you get elected and where there's elections. I can't say what I was thinking about saying because this is YouTube and they don't like us talking about that. But whenever there's an election on all levels, oh, ABBA had a song, money, money, money. So always remember, even if it's raining, your vote matters. Because this could be you, this could be your sister, this could be your son. All it takes is the wrong place at the wrong time and a shoddy police investigation. There is so absolutely that this has gone to trial it's a crime in itself. But no one in the DA's office will suffer anything. No one. Well, Canton Police Department might be another problem because apparently Proctor can lose his job if this goes the wrong way. So he has a bias, so he could be incentivized to lie. But other than that, none of these officers who ran around out there in the front yard with snow blowers, they won't lose their job. Any of the officers who decided not to go and canvass every ring camera in the neighborhood, they'll be on work Monday morning as well. This was one of their brothers in blue. And what did they do? I've seen crackheads get a better police investigation than this guy got. And I'm very generous. I'm giving her a 60% chance to be found not guilty after watching today. I was at 25% guilty before. After seeing Bev today, sadly, it went up. So just remember, it could be you. Well, bye, Helen. Yeah, but at least you did it, because a lot of people will just throw away their jury summons. Juries are always unpredictable, and that's why I'm saying even walking into the courtroom is a coin flip. And then you just subtract for those 50-50. And with Bev, I don't like her odds with yeah. The judge made 2 specific comments today that shows a total bias. Why is CM doesn't call Proctor as a witness, and for some reason O'Keefe is on the defense witness list? Yeah, that was 2 weird statements. Yeah, you are on jury Saturday because we'll have a mock trial. Because can I back up any of all the stuff I'm saying about how you should do it? If you don't know, we are having a mock trial Saturday at 2 p.m. where Shizzy Wisnot, great streamer, go follow him, and I will try a case before the Honorable Dave from MLS, where I will be the prosecution, Shizzy will be the defense attorney. And it'll be interesting to see if we can kind of do the stuff that we always yell at people in courtroom should do. But other than that, yeah, because I see the odds. Well, I see them in favor of it, but I would rather go in there and believe it's an uphill battle than go in there and think I've won the game. But other than that, tomorrow Jamie and I will go back and revisit an old case that inspired this banger of a hit.
In this crazy world, girl, I need to know why you're so cold. Tell me what's the score. You say you hate me over grape, is that all? Come on, girl, let's face it, we had a ball. Why can't you see that you are mean to me? I'm losing sleep, baby, can't you see I'm tired of playing games? I just wanted something on this side, my wife, oh my girl, I won't let you go. We met on Facebook or at the gas station. I took you to Cheddar's and a movie, and you didn't mind I catfished you at first, but my nephew was a snitch, that little bee. Why can't you see that you are mean to me? I'm losing sleep, baby, can't you see I'm tired of playing games? I just wanted something on the side, my wife, oh my girl, I won't let you go.
So that's tomorrow's program, because they don't work tomorrow in Massachusetts. And Ariel, maybe we'll use the alternate, but if you're picked, you have to have to show up, because else we'll put out a bolo for you and have you drugged to court. Mr. O'Keefe is on defense witness list. I think the motion exempts him from being sequestered, meaning he can attend the trial. Yes. They talked about the family had to be sequestered until they had given their testimony. But I also understood it like that didn't pertain to him. But I'm not sure. What he is doing on her defense list is probably to be a character witness and say, no, their relationship, as all relationship, has their ups and downs. But he was happy we had a conversation about, or something that I what else could I think? I don't know why you would call his dad other than that, because he has no knowledge of what happened. Maybe about the harassment he suffered from the Albert family, but it has to be first-hand information. It can't be hearsay. Yeah, either that or that the Albert's kid harassed him at his house, and he saw those pictures of them drinking beer on his porch while he was on vacation. That's what I'm thinking he's there for. Other than that, nothing much today, other than his dad wasn't in court today. Okay. I don't know what he looks like. I found out how his brother looks. He looks mad. Other than that, chicken time for me. I'll be in the Discord voice chat later, and please join us. It's the new Discord members chat has it. If you're not a member, you're more than welcome. Reach out to Whiskey, Marissa, Jamie, or Irish, and they'll figure a way to get you into the Discord. Come hang out. We have fun and joy and seasons in the sun. I turned that one around. He used to go to church with her, so it's probably character witnessing. That's a strong card to pull his dad if he's going to testify she was a good woman. But no, a little thing before all of you go away. The lead investigator testifying in the middle of the case. That's one I'm thinking over while I prepare my chicken tonight. But go out and have a wonderful evening. Hopefully, I'll see some of you over on the Discord. I think I have to talk with some of the ladies about the trial stuff. We will be back tomorrow. I will start a bit earlier tomorrow, and we'll do that pro se case out of Texas we started yesterday just to fill some time, so we get ready for Monday where we have to sit here and hopefully have a great case. I really hope it doesn't bog down in a lot of experts and a lot of objections. But as our lovely friend says, hasta la taco, and go out and enjoy yourself a bit.
Your Honor, I apologize.
What exhibit are you referring to?
I'm going to make this 100, Your Honor. 100, because it is 100% correct.
Objection, Your Honor.
It will be at 2 p.m.
See the
2
lawyer's
p.m. on
face?
Saturday.
Okay, we have to go back and
Widower case.
Did you, whether it's true or not, believe that Mr. Randolph had slept with your wife?
I wouldn't care.
You wouldn't have cared?
No.
Did you believe he had slept with your wife?
No.
Did you believe he slept with your mother-in-law?
Probably did.
wait a minute. I need this story time.
Everybody has.
Everybody has.
Everyone has slept with his mother.
If I showed you.
Oh my God.
I'm having a Jamie moment. And the way he just said it, he was just like, everyone did. Things on YouTube.
Mr. Randolph, do you?
I got that against man. You don't know.
Called him chicken shit.
That's right, you was chicken shit.